Members of Parliament, support staff, radio listeners, TV viewers, all following this meeting via social media, members of the media, those persons in the tribune, ladies and gentlemen, good afternoon. I welcome you to the continuation of public meeting number 13 for today, Monday, April 7, 2025. At this time, I want to give a special word of welcome to the Honorable Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes Jr. and his support staff. We have established a quorum of 10 members, and I invite you to stand for a moment of silence. Thank you. I have received notice of lateness from MP Peterson, and I ask if any member wishes to take the floor for notifications. I acknowledge that MP A.M.R. Labega had done so, and I now invite MP Labega to take the floor. MP Labega, you have the floor.
Good afternoon, Madam Chair. Good afternoon to the Griffier. Good afternoon to my fellow colleagues. Good afternoon to the Minister of Roaming Support Staff and everyone here listening in the Tribune. Madam Chair, through you, I'd like to congratulate the Minister of Roaming and his team for the completion of the booths in the Joyce and Arnell Carnival Village. This is a task that has been outstanding for over 8 years since Hurricane Irma, and I'm glad it's just in time for the carnival season. And finally, we have a completed Carnival Village. So once again, thank you and your team. Job well done. Thank you, Madam Chair.
Thank you, MP Labega. I continue and I give the floor to MP Otley. MP Otley, you have the floor for notifications.
Thank you, Madam Chair. Good day to the viewing and listening public. Madam Chair, I see we have some meetings scheduled supposedly this week, the 9th. I find it, with the magnitude of importance for these meetings, I find it a bit disheartening that 6 members of Parliament, both opposition and coalition, will not be here for these meetings, including one with the Minister of VSA, where the chair lady of the committees will also not be here for these meetings, and one pertaining to the budget was a request whereby we wanted an update on the budget. And Madam Chair, the reason I say this is very important, you had a very eloquent interview the other day, and it was stated that the budget issues right now is between, basically, at the government, finance and legal and review. And then I listened to press briefing, and the Honorable Minister of Finance then says, when asked about the budget, we are waiting on Parliament. So somewhere there's a quagmire, or somewhere there's something is not clear. Hence the reason that it is very important that all members of Parliament be here. But again, to each his own. But I would like clarity on that, Madam Chair, if you can answer, because for the ministers to say, hey, we are waiting on Parliament for the next step of the budget, which holds the country basically hostage at this moment, it's a very damning thing, because as a member of Parliament, I don't know anything about it.
Thank you, MP Otley. I continue and I give the floor to MP Lewis. MP Lewis, you have the floor.
Good afternoon, members of Parliament. Good afternoon, Madam Chair. Good afternoon, the Honorable Minister of Roaming. Madam Chair, I just want to highlight today was a very sad day for me and many others, as my former cabinet staff, John Morisseau, his brother, was laid to rest today. It just shows you that St. Martin has a lot of people grieving at this time, because many others have lost loved ones since this year has opened. And I just would like to notify everyone that we should live good, because we never know the day that our last breath will be taken. Mr. Morisseau, that was laid rest, lost his life suddenly, just on a heart attack. Anything can happen to any one of us, so I think we're just supposed to live good with each other and make life worth living. Thank you, Madam Chair.
Thank you, MP Lewis. I don't see any other member requesting the floor for notifications. I want to join those persons who have expressed words of condolences to families, friends, and colleagues of anyone we have lost, especially during the last couple of days. To these condolences, I want to add condolences to the family and friends of the late Dennis Pantoflet. You would know that Mr. Dennis Pantoflet served the island of St. Martin in several capacities during the days of the island territory, St. Martin. To name a few, of course, Island Council member, commissioner, as well as acting lieutenant governor for a period of time. He passed a couple of days ago, and thus, on behalf of the Parliament of St. Martin, I extend condolences to his family and friends who are left to mourn his loss. I have taken note of the comments, maybe questions asked regarding the meetings of this week. And I can inform those who not only mentioned it during this meeting, but also to me in private, that the work of Parliament needs to continue as good as possible and as we can. And thus, if, like we have this week, persons are traveling, however, I would have ascertained that there is a majority of persons, of members of Parliament on the island, as much as possible, and especially if we get the appearance of the minister in question, if the presence of a minister has been asked, then those meetings would be scheduled. It also needs to be noted that while definitely travel like the one upcoming now is on behalf of Parliament, but members are not obliged to travel, especially to Part Latino. The choice to travel is actually of the member of Parliament. So with that response, if it is such, members of Parliament, thank you. As I was stating, so with that being response to the matter of meetings and scheduling while members of Parliament are traveling, and again, according to my count, we have a majority of members still on the island, and I hope that all will be willing to attend the meetings and will be able to attend the meetings as called. I am not going to respond and second-guess any statement by anyone else, but I can speak for myself as President of Parliament, where the draft, or no longer draft, where the budget 2025 is concerned, and that is indeed that the government, following receipt of the letter which has been shared with members of Parliament, from Parliament to government, would have to make a decision about the way forward for the budget, which could or could not include Parliament. I don't know yet which one would be, which route will be chosen by the government for the corrective action that needs to take place, and thus I too await from the government their response to this. I hope it is as soon as possible, and I also hope that all stakeholders will work together in order to get the budget 2025 ratified. That is where it is right now, in the process to be ratified, and whatever measures need to be taken in order for that to happen is, again, I repeat, with the government of St. Martin. Members of Parliament, we continue with the agenda point for today, and that is deliberations with the Minister of Public Housing, Spatial Planning, Environment and Infrastructure regarding the delayed publication of building permits and ensuring legal compliance and procedural clarity. This document is listed on the IS 654. It is dated February the 24th, 2025. I just want to remind members of Parliament and all concerned that this being a public meeting, we do have the possibility, which can be granted by the chairperson of Parliament, for interruptions. And the interruptions, I repeat again, should seek clarifications, can challenge assertions, or contribute additional information, but in any case should always consist of very brief remarks without any introduction. So going back over to the agenda point, as I mentioned, on February the 24th, Parliament received a letter from the MPs Doran, York, and Irion with the request for an urgent public meeting of Parliament to discuss the point that I mentioned. The meeting was convened on March 12, 2025, and after a presentation by the Minister of Romy in accordance with the speakers list, members of Parliament were given the opportunity to pose questions to the Minister in the first round. The meeting was then adjourned to allow the Minister time to prepare the answers to the questions posed by the members of Parliament in the first round. And so it is good to know that a continuation of this meeting was scheduled to be held on March 26th, but was postponed until further notice upon request of the Minister. Today, the Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes Jr., has returned to Parliament to provide the answers to the questions posed by members of Parliament during the meeting of March 12th. So at this time, I give the floor to the Minister of Public Housing, Spatial Planning, Environment and Infrastructure, Mr. Patrice Gomes Jr., to answer the questions posed by members of Parliament in the first round. Minister Patrice Gomes, you have the floor.
Good afternoon, Chair Lady, members of Parliament, viewers and listeners in the Tribune and online. I'll begin first with the questions from the Member of Parliament, A.M.R. Irion. His first question: will you instruct all projects that lack a civil works permit to halt construction? The government acknowledges that a process which was legally in place and reinforced in 2021 has not been properly implemented. Since taking office, discussions regarding the need for civil works permits have persisted. Noting the very broad stroke reasons as to why a civil works permit is needed, the decision was taken to develop an exemption policy that may be used to inform legal changes to the existing legislation in future. We are currently assessing the best and most practical solution that serves the public interest while considering the ministry's capacity. As stated during my presentation, this should be finalized within short. While the intention is not to review all past decisions and stop all current construction that lacks a civil works permit, if the lack of a civil works permit causes significant issues during construction, the ministry will go back to the law and ask for this to be remedied. Will your ministry conduct inspections to ensure compliance with civil works permits? The ministry does and will continue to conduct controls, taking into consideration the previously stated. How does the lack of a ratified budget affect hiring and staffing in the ministry? The hiring process is not being affected by the non-ratification 2025 budget. The vacancies that are budgeted for in 2025 budget are the remaining vacancies in 2024 budget that we were unable to fill. Currently, we are busy filling 2024 budgeted vacancies as follows. We are in the final stages of hiring 1, the financial controller, 2, a judicial policy advisor, 3, a quality manager, and 4, a policy advisor, and 5, department head for domain affairs. How long does it take to publish a permit in the National Gazette? Every 2 weeks, the permits department compiles all permits issued in the document designated for the National Gazette and government information page. DCOM and General Affairs receives the document to be published from the permit department and informs the department when the publication date will commence. MP Irion's final question: do you hold yourself accountable for all government decisions, even those in the Council of Ministers? Decisions are made based on majority vote. Individual ministers can disagree with a decision, and motivation, if any, is noted. The decisions of the Council of Ministers are the official government positions and as such must be executed by all ministers.
Minister, if you would indulge, I would allow MP Irion to make his interruption. MP Irion.
Thank you, Madam Chair. Good afternoon, all. Minister, based on your answer regarding the civil works permit, you mentioned the policy, and you said you made it clear that you're not going to subject all past projects on identifying if they have a civil works project permit or not. But then it becomes very subjective because you said if it disturbs, but who decides that? Who decides which or which not? So out the policy, it becomes very subjective and it looks very then like you kind of targeting and certain entities or certain people. And that was one of the questions I posed already. How are you going to do this? And you didn't answer the other question I had, but I'll get in the clarifications.
Thank you, MP Irion. I now invite the Minister to continue. And Minister, if you can address the point raised by MP Irion.
Yeah, thank you, Madam Chair. If you can submit the question, MP Irion, or clarification around, that'd be great. And when it regards to serious issues for things such as things like access, obstruction, if you're excavating and there is material that we don't know where it's going, how it's being deposited, those are serious issues. And it's also regulated in the civil works permit, exactly. The question is now from the MP T.J. York. What definitions does the building ordinance provide for residential, commercial, and mixed-use properties? I refer to Article 1 of the building ordinance for the definition of gebouw, woning, weg, openbare weg. No other documentations and definitions are included in the building ordinance. What does Article 22 of the building ordinance specify regarding permit approvals and denials? Article 22 states, a decision to grant a resident a conditional building permit or to refuse it in whole or in part shall be always substantiated and may only be based on one or more of the following circumstances. 1, that the application, the drawing, the description of the building, of part of the building does not comply with the regulations issued by pursuant to this regulation. 2, that the building, also in connection with the construction method used, cannot be considered to have solidly that it does not pose a danger to the lives of the residents or users or to the environment. 3, that the dimensions or rooms or staircase or the number of layout of toilets or the number of access routes for light and air are considered insufficient. 4, that the use of the building or part of the building is considered to be harmful to public health or to the health of users. 5, that the building or part of the building will disfigure the surroundings or will be a nuisance or fire hazard to surroundings due to its location or construction method. 6, that the road on which the house will be located does not meet the requirements that are set for the route, width, and construction thereof, taking into account the nature of the house and the requirement of the road being passable for the government services. 7, that the building plan is in conflict with the zoning regulations of a development plan or the regulations pertaining to an approved subdivision plan in which the land involved in the application is included. And finally, that a permit pursuant to the monument ordinance is required or that the building plan has not been granted. MP York's third question, what mechanisms are in place to ensure Article 22 is properly implemented? Article 22 is an article in the is an article in the building ordinance, which is a land ordning, national ordinance. In our assessment of proposed plan, many aspects are considered. The Ministry of ROMI aims to ensure overall sustainable spatial development for the entire island, which is and cannot be limited to the building ordinance and parking standards alone. We look at the bigger spatial planning picture and therefore assess projects from a broad perspective. So the hillside policy, the beach policy, spatial development strategy, zoning plans, climate change, nature, environment, infrastructure, etc., are all considered when projects are assessed. With the controversial construction projects already known to the ministry before media attention, the ministry should, in principle, be aware of all projects and actions taken. This awareness differs between individuals or departments within the ministry depending on the role played in a particular project or action. Therefore, awareness of projects before media attention is there for some and for others not. Can the minister provide a list of cases where policy advice was ignored when issuing permits? I would ask your indulgence, MP York, this information to be provided to you via a lobzook, which I understood you already submitted a request. So I'll have that for you just to avoid everyone's information on the floor of Parliament. The MP's sixth question: what are the consequences of discretionary decision-making in approving or blocking projects? The exercise of discretionary decision-making in approving or blocking projects carries significant implications for both the country of St. Martin and the Ministry of Rummy, particularly when proper infrastructure, proper procedures, legal frameworks, and established policies are not adhered to. Below are some of the potential consequences. And it's quite lengthy, so excuse me. The first, legal and financial risks. Failure to adhere to established legal procedures may lead to legal challenges from affected stakeholders. If decisions are made arbitrarily or without proper justification, this could result in lawsuits against the government, potentially leading to financial liabilities in the form of court-ordered damages or compensation. The second impact, erosion of public trust and institutional credibility. When discretionary powers are used inconsistently or without transparency, public confidence in government institutions, particularly in the Ministry of Rummy, may be severely undermined. A lack of transparency and accountability can foster perception of favoritism, unfair treatment, or even corruption, which weakens governments, structures, and democratic institutions. Thirdly, uncertainty for investors and economic impact. The private sector relies on predictability and a clear regulatory framework when making investment decisions. If projects are approved or denied based on discretionary decisions rather than clear, standardized policies, it creates uncertainty in the business climate. Investors may be deterred from engaging in future developments, ultimately affecting economic growth and employment opportunities. Fourthly, environmental and social consequences. Discretionary decision-making that disregards environmental impact assessments or zoning regulations may lead to unsustainable development. Unchecked approvals can contribute to environmental degradation, loss of public space, and inadequate infrastructure planning, while arbitrary rejections may stall beneficial projects that align with sustainable development goals. Finally, administrative and governance challenges. Inconsistent decision-making may create administrative bottlenecks where approvals are delayed or projects are halted due to a lack of clear guidance. This can strain government resources and create inefficiencies within the Ministry of Rummy. Furthermore, the absence of adherence to policy may expose public officials to accusations of abuse of power, misconduct, which could lead to internal investigations or disciplinary measures. In conclusion, to mitigate these risks, it is crucial that discretionary powers are exercised within a well-defined legal and policy framework. The Ministry of Rummy must ensure that all decisions are based on objective criteria, transparency, and accountability. Strengthening institutional frameworks, enhancing public communication, and ensuring adherence to due process will help safeguard the environment, the integrity of the decision-making process, and promote sustainable development for St. Martin. The MP's seventh question: why does the ministry announce initiatives, example, illegal garage investigations, before finalizing execution plans? The ministry announces initiatives to bring awareness of the direction its plan could take. Some initiatives require a change in behavior and are announced to allow people the opportunity to prepare and make necessary changes to be in line with what is coming. For example, early in the year, I announced the ministry will be enforcing removal orders. The first set of removal orders were carried out only 3 weeks ago. This allows for not only awareness of building, but also reduces potential for claims. In some respects, this also requires illegal timelines. Very similar is true for the controlling of illegal garages. Moving on to the questions of the MP D.M.R. Labega. What actions will the minister take to address ongoing permit concerns? The ministry has already addressed the issue with regards to necessary manpower. In addition, building the redundancy in the department will help mitigate any reoccurrence. How will the ministry balance project approval when resolving past issues? Given current workloads, limited capacity, and the need to move to strategic decision-making, past issues are resolved as they arise. Should a decision from the past need to be addressed more in depth, necessary attention will be given to it. Moving to the questions of the Honourable MP Egbert Doran, do you perceive the delay in the permit publication as negligence on your end? I do not perceive the delay in permit publication as negligence on my end. I acknowledge that redundancy was not adequately built into the ministry, and we are working to address this. If not negligence, how do you explain the impact on public objection rights? For every issued permit, Madam Chair, a publication may be presented to allow the public the opportunity to review and object if necessary. Delays affected this process, limiting the window to public objection. Important to note is that based on jurisprudence, a person can still object within a reasonable time frame if he or she comes to know of a permit too late because of late publication. This, of course, needs to be considered by the judge. What were the significant delays of building permits? Why were there significant delays of building permits from May to October 2024? Important to clarify here is that there was no delay in permits, but in the publication of approved permits. This is not new, but what makes this case different is that during this period, May to October 2024, there was an absence of key staff to ensure this was executed properly. If you are aware of delays, why was no action taken? As Minister, I was not aware of this. From the ministry, I understand that the pickups were continued, but due to heavy workloads and limited staff, the preparation of the documentation for the National Gazette was not carried out. Since learning of this, I have taken steps to ensure redundancy is built into the department with clearly written procedures to have this carried out by other staff should similar instances occur in future. Why were you criticizing previous administrations for non-publication while during your tenure you also had unpublished permits? Madam Chair, through you, I am not sure where the MP gets the impression that I criticized previous administrations for non-publication. If I recall, there was a question posed to me and taken up by the press regarding the impact of the late publication of 2 permits as related to the objection process. To this, I answered that late publication and misclassification may have an impact on the right of persons to object to a development. The MP's perception of this as criticism is unfortunate. This is not criticism, it is a plain, simple, and unemotional fact. The same way my late publication may impact the right to objection. What makes my case different is that I took ownership of the issue, apologized, and I'm putting measures in place to mitigate it from happening in future. Why did you initially support Ville-Vin, but later shift your stance? My position on Ville-Vin has never shifted. As minister, I was invited to say a few words about the development. In my discussion with the developers, I explained to them that there are certain elements in their development that need to be considered and reviewed. The developers welcome this very open approach and their willingness to correct these oversights from the past. This is why I purposefully chose the words partners. If and when things go wrong, they are addressed and we move on. As is offered to all developers, local or foreign, I ensure a dedicated team within the ministry to help resolve issues as they arise. Some choose to speak with the team, others choose different routes. As Minister of Rummy, it is my duty to ensure a balanced approach across various portfolios. With a project of this magnitude that impacts significantly the nature and environment, it is imperative that we proceed responsibly. The developer and the ministry are collaborating closely to ensure this, and we are looking forward to executing this properly. Why didn't you mention the need for environmental impact study at the Ville-Vin event? As previously stated, the need for the environmental impact study was already communicated to the developers ahead of my speaking at the event. Their commitment to ensuring this takes place, as well as willingness to address broader matters of the project, is why the word partner was chosen. Since then, the respective teams have had several meetings and are working to align the project with the ministry's overall objective for sustainable development. If you believe Ville-Vin was issued incorrectly, why haven't you revoked it? The grounds for revoking a building permit are clear and actually very short. If the work has not commenced within 1 year from the date of when the building permit was granted, or if the work has been suspended for a year. If in carrying out the work to which the building permit relates is a deviation from the regulations laid down by pursuant of this ordinance. Having said that, Madam Chair, there's several reasons not to approve a building permit. All this has to be considered by the minister ahead of approving the permit, and thus there's very little room left to revoke any permit without litigation in most cases. Are your decisions driven by legal framework or by external pressures? Decisions made by the Ministry of Rummy are guided first and foremost by established legal frameworks, policies, and regulatory procedures. The Ministry remains committed to upholding the rule of law, ensuring that all approvals, rejections, and discretionary considerations align with the country's legal standards and sustainable development goals. While media coverage can bring attention to certain issues, it does not determine government's actions. The Ministry remains steadfast in making decisions based on facts, due process, and the long-term interests of St. Martin. Why do banks classify, this is the MP's 10th question, why do the banks classify certain properties as residential while your ministry classifies them as commercial? The classification of the properties by the Ministry of Rummy is based on zoning laws, spatial development plans, and relevant regulatory frameworks that govern land use on St. Martin. These classifications ensure proper urban planning, environmental sustainability, and infrastructure development. Banks, however, classify properties based on financial risk assessments, loan eligibility criteria, and their own internal policies. The classifications are primarily for mortgage and valuation purposes, which may not always align with zoning regulations. While the ministry's classifications determine how property can be legally used, banks assess properties based on market value and financial considerations. Who misclassified the controversial permit under discussion? The classification of the permit was based on information available at the time of issuance. If an error occurred, the department is reviewing how it happened and will address it accordingly. How does the ministry define a mixed-use project? A mixed-use project includes multiple functional usages, better word, within a single development, such as residential, commercial, and recreational spaces, designed to complement each other within a unified plan. How many permits issued under your administration follow the same misclassification practices you criticized? Again, no criticism, but at the time of this meeting, Madam Chair, the ministry was not aware of misclassifications during my tenure. It is important to note that a mark of good governance is not an administration without mistakes, but one that acknowledges that they can happen and provide corrective measures. The practice of saying, oh, you see, you did it too, does not help the situation at all and only deflects responsibility and misses the opportunities for growth and improvement. Can you highlight major decisions taken by you without blaming past administrations? The Ministry of Rummy remains focused on executing its mandate through responsible governance and forward-thinking decision-making. Historical context is needed to understand challenges and constraints. This administration takes full accountability for decisions made under its tenure. If the MP feels that in giving historical context, he may be negatively or positively affected, and thus sees that as blame, this is for him to reflect on. Major decisions taken include restoration of critical infrastructure and drainage, addressing outdated policies, enforcement of regulations, and commencement of preparation for identified projects going forward. As well, of course, as interventions made on decision-making regarding the landfill. Have you ever overturned negative advice, a negative department permit advice into a positive one? To date, I have not overturned a negative permit advice, turning it into a positive one. Important to note is that overturning any negative advice into a positive approval is in itself not wrong, but it must be substantiated. In our review of cases where this has happened, very little substantiation is given. Are you suggesting the past staff of the ministry were giving incorrect advice? The minister is ultimately responsible for making the right decisions, regardless of the advice provided by the department. While the ministry relies on technical and policy-based recommendations, it is the minister's duty to ensure that all aspects are carefully considered before any final decisions can be made. It is possible that at times advice given did not reflect every relevant aspect of a matter. Additionally, there may have been instances where policy advice was whether consciously or unconsciously not sought or fully taken into account. Allow me to give one example that I've encountered during my tenure as Minister of Romy. In a discussion I had with staff, it was stated that all developments are allowed to build places for workers to live. And this has always been done. This assumption rests on Article 26 of the Building Ordinance, which states that no building permit is required for the construction of temporary sheds, barns, sheds, and the like required for a building. Article 28 goes on to state that the provisions concerning homes do not apply to sheds, barns, huts, tents, and other similar establishments intended for temporary residence, unless the residence lasts for more than 1 year. Less than 1 year. The commonly occurring practice is not just how things are done, but a well-regulated law that goes on to state that it is prohibited to give, take, or have establishments, as referred to in the first paragraph, for residents other than with written permission from the minister, and other than in compliance with conditions attached to the permit in the interest of health, safety, and morality. Thus, the Minister of VSA may also have a role to play in building permit process. While the example in no way diminishes the work and expertise of the ministry, it does indicate the need for greater knowledge of existing legislation in order to adequately advise ministers. I remain committed to making decisions in the best interest of Martin, ensuring transparency, due diligence, and adherence to applicable laws and policy frameworks. You stated that your first 3 years will focus on investigations and executing the last year. What exactly are you investigating? Allow me to clarify this statement. In no way means a building stop. This statement was in response to questions posed during press briefing. Very little attention had been given to legal and structural changes needed in the ministry. Moreover, we are currently dealing with several cases against the government that question what has been called by the court as unclear and unstructured decision-making. When similar cases are brought forth, unless we have a clear position, a decision, certain requests will be denied or postponed for decision-making, of course in close consultation with the requesters. Why are large-scale projects approved while others are blocked? Large-scale projects are approved or denied based on their compliance with legal requirements, zoning and environmental regulations, and overall alignment within the country's development plans. Each project is assessed with its own merits, and decision-making is made accordingly. If the MP has an example of denied large-scale permits during my tenure that he's asking about, I am more than willing to give more clarity. What criteria do you use to approve some high-end projects while rejecting others? The criteria to approve all high-rise projects are the building ordinances, the building code, and the parking standards as your policies. If the project is near the beach policy is considered and taken into consideration, as well as ideas around climate change. Was GB consulted before approving the Maho high-rise? Yes, G was consulted before approving the high-rise of the Maho area. This took place on October 24, 2024. This meeting. What legal basis do you have to deny a permit if it meets all requirements? I said before, I'm not going to read this again because it's quite long and I have a heavy tongue today. The Article 22 of the Building Ordinance, as stated by my questions to, I believe, the MP Irion, there's about 8 reasons to deny a building permit, and if you'd like me to read them again, I can, but if it can be explained, okay, MP Irion loves to hear my voice, so we'll do it again. The legal basis for denying is quite extensive. Article 22 states, a decision to grant a conditional building permit or to refuse in whole or in part shall always be substantiated and may only be based on one of the following circumstances. One, the application, the drawing, description of the building or part of the building does not comply with the regulations issued by the pursuant to this regulation. Two, that the building, also in connection with the construction method used, cannot be considered to have been built solidly, and that it doesn't pose a danger to the lives of residents or users to the environment. Three, the dimensions of the rooms or staircase, or the number of layout or toilets, or the number of access routes for light and air are considered insufficient. Four, the use of the buildings or part of the building is considered to be harmful to public health or to the health of the users. Five, that the building or part of the building will disfigure the surrounding environment, the surroundings, or will be a nuisance to the fire or a fire hazard to surroundings to location or construction method. Six, that the road on which the house, read building, will be located does not meet the requirements that are set forth in the route, width, and construction thereof, taking into account the nature of the house and the requirement of the road being passable for the government services. Seven, that the building plan is in conflict with the zoning regulations of a development plan, or that regulations pertaining to an approved plan in which the land involved is not included. And eight, that a permit pursuant to the Monuments Ordinance is required and has not been granted. Are you denying permits based on personal or party sentiments? No, as stated, denying permits are based on existing regulations and policies. Important to note, like all parties, PFP is a collection of people with different backgrounds, positions, and interests. MP Peterson, for example, hates gambling. I, on the other hand, like a little bingo. It's about how best to bring those various skills together in the best interests of St. Martin, and not personal agendas. Are you implementing policies to restrict large-scale developments? The ministry is not implementing policies to restrict large-scale developments. The ministry assesses these developments fit, not only within our building legislation, but also within our approved spatial development strategy, meaning our spatial planning vision for St. Martin. We assess density in relation to the effect it may have on nature and environment, air safety, traffic circulation. The surrounding road pattern must be able to properly handle the traffic, parking needs, etc. The strategy was presented to Parliament and approved by previous administrations. The following is taken directly from this vision. Based on the current market and outlook with respect to the theory of tourism, the following space reservations should be made for spatial planning point of view. New large-scale hotel resorts might be facilitated at strategic locations with focus on conference and events tourism and/or luxury brand name hotels. The development of a niche market for small-scale boutique or lifestyle hotels can be facilitated in terms of zoning under environmental conditions. And it goes on to state more. So in short, no, we're not at all mitigating a lot against, we're not at all stopping large-scale developments. We're actually following exactly the strategy plan vision. It is making sure that we do it the correct way. Are you planning a construction moratorium? Stated on several occasions, there is no plan for a construction moratorium, or more commonly, a construction stop. Can you confirm that all permits issued under your administration fully comply with legal standards? Madam Chair, yes, through you, I am committed to ensuring that all permits issued under my tenure comply with the applicable legal standards, regulations, and procedures. Each permit is subject to review based on established criteria, and the ministry strives to uphold transparency and due diligence in the permitting process. If concerns arise regarding any permit, the ministry remains open to reviewing cases to ensure that full compliance with the law. Did you issue an 18-story permit did you issue an 18-story hotel permit against policy advice? And through you, Madam Chair, if I can ask the MP to clarify, does he mean the 18-story, or does he mean the 10-story in the Maho area? This is a clarification question. So there was a question through you, Madam Chair, to the MP posed regarding if I approved an 18-story hotel, MP Doran. Sorry, my apologies, Madam Chair.
Minister, in order for you to give the appropriate answer, I will allow, you said it was, you're answering MP Doran?
Yes, so there was a question noted here.
Okay.
It's noted as, did you issue an 18-story hotel permit against policy advice? So the question is this an error, or was it a 10-story hotel advice in Maho? Yeah.
MP Doran, could you briefly respond so that the minister can continue with his answer?
Thank you, Madam Chair. Good afternoon to everyone. That question doesn't ring a bell. For sure, I didn't ask that question, so maybe it was misquoted. I'll check in the notes and come in the clarifications. Thank you.
Fair enough. Thank you, MP Doran. So, Minister, if you just skip that until
okay.
the MP can give clarification to that.
The MP's next question, can zoning be used as a basis for decision-making even though it lacks legal standing? Our approved and established spatial development strategy mentioned before is further translated into the draft zoning plans, which is the reason why, even though not legally binding, we take the zoning plans into consideration when decisions are made on building permits, particularly in light of Article 22. Paragraph 5, which considers hindrance and nuisance of a development to the environment. Our spatial development strategy plays a crucial role in determining what is desirable in certain areas and what is not. Desirable in relation to spatial aspects, air safety, traffic congestion, parking needs, of course, because higher density means increased parking and traffic, etc. Thus, our zoning plans can be used as a guidance when determining what can be considered as nuisance and hindrance to the environment and what will likely not be. To further answer your question, the challenge of the draft zoning law is that it is often arbitrarily used. In one instance, we see where the draft zoning law was used to deny an applicant's request for additional heights. Yet the same minister deviated from this draft zoning law, allowing varying height restrictions in areas where it is not allowed. It then begs the question similarly posed to me, were decisions driven by legal framework or by personal pressures? Can a minister assess projects beyond building ordinance and parking standards? Yes, certainly. In our assessment of proposed plan, many aspects are considered. The Ministry of Romy aims to ensure overall sustainable spatial development planning for the entire island, and which is and cannot be limited to the building ordinance and parking standards alone. We look at the bigger picture, spatial planning picture, and therefore assess projects from a broad perspective. The hillside policy, the beach policy, development strategy, zoning plans, climate change, nature and environment, infrastructure, etc., are all considered when projects are assessed. Should a civil works permit be required for building a foundation? Civil works permits and building permits are two separate things. Building foundations would fall within the building permit. Civil works permits regards the manner in which the land around is used. Did the permit and ROM department have conflicting views on the controversial permit? Let me come back to that, Madam Chair, because I think there's an issue with this question. Okay, we'll come back to it. The MP's next question, why do certain projects such as Westview face significant scrutiny while others are approved quickly? Projects undergo different levels of scrutiny in their complexity, environmental impact, zoning compliance, and public interest. Some projects meet all legal criteria and can be approved quickly, while others do not fully comply with regulations and therefore require further review, adjustments, or may face delays in approval. Additionally, the ministry has no influence over which projects attract media or public interest. While some projects receive more external scrutiny, all are assessed based on the same legal and regulatory framework. Why is there more scrutiny on local developers than on foreign-backed projects? This claim, Madam Chair, through you, is incorrect. The ministry applies the same legal and regulatory standards to all projects, regardless of the developer's background. Every case is treated equally, with decisions based solely on compliance with zoning laws, environmental regulations, and other applicable requirements. Moving on now to the questions of MP La Cruz. Why is the ministry spending $100,000 on a strategic plan from Irion Associates? The ministry is not spending $100,000 on a strategic plan. This was a discussion within the Housing Foundation for which a decision has been taken to cancel this engagement. How many housing permits are currently ready for execution? This is within the context of the Housing Foundation. Many of the permits received, roughly 19, have been executed. There are about 2 permits that are still need to be executed pending financing by the Housing Foundation. Does the Housing Foundation still have land allocated for new developments? Yes, the foundation has land for new developments. To the questions now of the Honourable MP Ludmila De Wever, how can the ministry ensure the public has better access to permit information? The Ministry of Romy keeps the public informed through regular updates on the government's official website and Facebook page. Important permit-related announcements, including application procedures, are shared via press releases and direct communication with the community. As did before, we are busy adjusting the type of information and details that we publish in the National Gazette. What processes exist to allow residents to raise objections before approvals? At present, by law, no process exists to raise an objection before a decision is made. In accordance with the applicable laws, stakeholders have a right to file an objection, a bisvar, or appeal, birup, after a decision has been issued. As stated during my presentation, the ministry is considering that a review ahead of approval is possible, but this may, of course, require legal changes. Will the government consider placing mandatory project signage construction sites to increase transparency? This is already in place. The issue here is enforcement and why we are focusing on administrative enforcement. Currently, projects must by law have a copy of the permit visible on site. The department is reviewing if we need to have legal changes made to make this a large billboard, as is done on the front side and referenced by the MP. What happens after a stop order is issued? When a stop order is issued, the developer can be given, if legally possible, the opportunity to have the violation corrected in an allotted time frame, but must adhere to the stop order. In the event the violation continues, the ministry can take additional legal action. How can the ministry ensure fair and consistent enforcement of permit regulations across all projects? The Ministry of Romy is committed to fair and consistent enforcement of permit regulations across all projects. All permits are subject to the same legal and regulatory framework, and enforcement actions are taken based on compliance with these standards. However, should limited capacity within the inspection department, not every case can be immediately addressed. The ministry is actively working on improving enforcement by prioritizing cases based on urgency and impact. Moving on to the questions of MP Lyndon Lewis. What do you mean by saying that the execution will only take place in the last year of your term? I answered that question already. MP, would you like me to repeat the question, or, okay. Anyway, I'll wait until he comes back, yeah. Through you, Madam Chair, would the MP like me to answer the question again, or would it suffice having been answered already for the MP Doran?
You may continue as
Okay.
the MP is not here to respond.
Can you clarify which building permits were delayed for the past 3 years? Yes, if they will be delayed. Building permits have not and will not be delayed for the next 3 years. I've been signing permits quite extensively. What was the approval process for the high-rise in Maho? The approval process followed the established permitting regulations, including evaluation by relevant departments, which were applied to ensure compliance with draft zoning laws, environmental and safety standards. Were environmental impact studies conducted before issuing the Maho area permit? Based on the advice from the policy department on the EIA, this was deemed not necessary. The ministry assessed the permit for the project in the area of Maho based on the draft zoning plans and air traffic safety regulations which the project complied with, meaning the allowable building height here is set at 30 meters, and the airport approved the height as well. Moreover, as minister, I discussed this and made sure that GB was informed and on board with the decision before it was taken. The ministry does not aim to require an impact study for all developments. When there will be likely be significant environmental concerns in the surrounding area, the ministry will consider this, of course, and does request it. What measures are in place to prevent overburdening the island's infrastructure with large-scale developments? This is where the draft zoning regulation comes into play. Areas around the island have a certain amount of capacity infrastructurally based on several factors, including what the area is zoned for. If a permit is approved without the necessary infrastructure being in place or without a plan for implementation of the infrastructure, this will inevitably have consequences negatively on infrastructure and, of course, on the project itself. Therefore, a permitted large-scale development should be in line with existing capacity. This includes assessing application alongside water, sewage, and traffic impact considerations before approvals are granted. How does your ministry balance economic development with environmental conservation? The ministry balances economic development with environmental conservation through the spatial development strategy and nature policy plan, promoting sustainable growth that meets present needs without compromising future resources. Recognizing the interdependence of economy and environment, we assess new developments based on their economic, social, and ecological impact, ensuring that growth aligns with environmental sustainability. For example, Article 28 of the Spatial Development Strategy ordinance requires that civil works be evaluated in the public interest. If an activity is at risk, if activity is at risk for irreparable environmental damage, the permit may be denied without strict conditions to mitigate environmental harm. What steps are being taken to enhance public participation in major development decisions? At this moment, there is much that can be achieved by enhancing the instruments that we currently have. For instance, the ministry will improve data provided and published permits, enabling the public to better assess major developments. Additionally, the ministry aims to increase the number of channels used to alert the public about all developments. For example, we plan to create posts on various social media platforms referencing the publication permits in the National Gazette and Landscourant. Well, the National Gazette, which is the Landscourant. This will improve outreach, ensure that more stakeholders are aware of all the permits. Furthermore, the ministry has already taken steps to inform the public about the processes for requesting information on planned developments and the procedures for objecting to them. This helps the general public understand and engage in the process to voice their concerns and provide suggestions. As stated during the presentation, the ministry is also considering the potential of notifying people about requests before processing. In the meantime, I am looking to suggestions made by the ministry in the past to have developers engage with communities before permits are approved. How will property prices be affected when zoning plans take effect? Prices may be impacted by the type of zoning we designate for the area. So different areas, of course, natural land use, where building is limited or prohibited, will most naturally have less value than residential or buildable land. Also important to note is that in having a green zone, it may actually also help to improve the value of your land if you're near to one. What plans exist to reduce high costs for the first-time homebuyers? The ministry is working on a housing plan, policy plan, we finalized as promised within June, which we will include how best to address this issue, especially how and where we can stimulate construction of affordable housing. Additionally, we're also working on revamping and finalizing the Mortgage Guarantee Fund. What plans does the ministry have to support agriculture sector? The draft zoning plan contains areas for agricultural purposes in the zoning plans. In addition, we have identified 2 areas for collaboration with the Ministry of TEAT, who oversees agricultural policy. Once finalized, these will be shared. Status of the dump, what actions are being taken to reduce landfill waste? The Ministry of Romney is addressing the landfill through the Emergency Debris Management Program, EDMP project of the Trust Fund. In addition, government is focusing heavily on waste reduction through diversion. This remains a critical part of the government's agenda. In February, I announced greater focus on this and met local businesses already involved in diversion activities to begin discussions around scaling up their models to their national needs. This includes businesses involved in processing of oil, metal, construction debris, green waste, and plastics. On the communications side, 2 meetings have already taken place as we begin to launch our green campaign, Think Green. How much garbage was removed from the cruise ships from the past year and is it sorted? There is no specific data available at the landfill regarding this question, as garbage is not registered based on the source. Neither is there a weighbridge currently installed. Private companies would manage this privately. We will be engaging with the harbor to get this information as well. How many building and civil works permits are currently under evaluation? Civil works permits total 46, infrastructure 22, demolition 18, dredging 5, and excavation 1. So civil works permits is currently 46 pending in the ministry. There's 22 for infrastructure, 18 for requiring demolition, 5 for dredging, and 1 for excavation. Building permits from 2021 to now have a total of 504 permits. And of course, the ministry indicated they have not counted 2010, 2020, from 2010 to 2020 have not been counted in this count. I'm not sure why not. Okay, what are the main causes of permit delays? The main cause of permit delays are lack of human resources, the staff being overwhelmed, and of course, the lack of digital processes, which we're currently working on, as stated. Are there legal or financial consequences of the ministry if permit approvals are delayed and beyond legal timeframes? No, however, applicants can take government to court, which leads to financial consequences such as paying legal fees or fines. Is the ministry facing litigation over permit decisions? As with any government entity responsible for permit approvals, the Ministry of Romy is occasionally involved in legal proceedings related to permit decisions. These cases can arise for both approved and denied permits. As stakeholders have the right to challenge decisions made through the legal system. Litigation is a normal part of the administrative process and serves as an important mechanism for ensuring transparency, accountability, and adherence to the law. Status of the restrooms in Phillipsburg, public restrooms, when will they be repaired? The Government Facilities Department, so under AZ, renovated the public restroom behind the courthouse in Phillipsburg in 2022. Yeah, thanks. Currently, it is in a fair condition, but Romy management has determined that an upgrade with commercial-grade amenities fixtures is needed to improve reliability of the toilets themselves. Over the past 2 years, the Romy Yard has been assisting with regular maintenance. A few weeks ago, there was indeed downtime due to water issues that was resolved on the exterior by GEBE.
Minister, if you give me a moment, I will allow MP Lyndon Lewis to make an interruption. MP Lewis, you have the floor.
Through you, Madam Chair, Minister, just today, again, I'm being reminded about the public bathroom behind the courthouse. Just today. So, Minister, sorry for interrupting, but I have to, because yes, the public is listening to this, and I am one of the MPs that they bombard. And you know before, I'm also one of the MPs that contact you, especially about the garbage and different things in the past. So I would not come here and make up anything. The individuals that are using the public bathrooms, those that are manning it, that are cleaning it, are complaining about it. Please have your staff check it out. Thank you, Madam Chair.
Thank you, MP Lewis. Minister, you may continue, and you can, if you can address MP Lewis's point, or otherwise, not at this time. Okay, Minister, you may continue with your answers.
Moving to the questions now of the MP A.M.R. E.C. Otley. Is it true that the land applicants will have to reapply under the new government land policy? It is important to note, now let me come back to that question, Madam Chair, if you excuse me. What are the consequences for permit holders who are unable to object to delays? Very similar to the questions posed by several MPs before. If a permit decision is not published in a timely manner, in the National Gazette, stakeholders may still appeal via Baruch once they become aware of it, as established in jurisprudence. This, of course, needs to be done as soon as possible, and it's up to the judge to decide if they will be heard or not. Why were major development projects put on hold while others, like Maho, were approved? Stated before, projects can be denied for several occasions, for several reasons. Apologies. MP Otley, can you clarify which projects you mean? that may have been put on hold, and by on hold, I assume you mean denied. So I can give some more clarity to that. Through you, Madam Chair, I'll move on. Why is Westview project facing additional scrutiny compared to other developments? As stated before, there's no additional scrutiny being given to the Westview project. Moving to the questions of MP Peterson, was a civil works permit obtained for the Westview project? Service permit was not obtained for the Westview project. If zoning laws limit building heights, why was the Point Pirouette project approved? All permits for the department are evaluated. The decision is based on building code. No, I think this is an error. Okay, so indeed, if zoning plans limit building heights, why was Point Pirouette approved? Because Point Pirouette fell in line with the draft zoning of 30 meters or less. Did the minister override policy advice on any major projects? No, I have not overridden any policy advice on any major projects during my tenure. What steps are being taken to hold former ministers accountable for decisions for questionable permit approvals? The ministry takes any potential criminal offense or irregularity related to the Ministry of Rummy very seriously, not only concerning the permit process, but all matters under the ministry's responsibility. If there are indications of wrongdoings of the relevant authorities, such as the Public Prosecutor's Office and other competent investigation bodies, are notified to determine whether further investigations are warranted. Additionally, irregularities are identified in past decision-makings or actions. Legal and administrative measures may be pursued to rectify any improper misconduct, ensuring transparency and accountability in all aspects of the ministry's operations. Were any cases brought to and handling COM concerning conflicts of interest by previous ministers of Rummy? Based on what we could find, no cases of conflict of interest have ever been brought to the Council of Ministers. What has been the norm is that in a time of conflicts of interest, ministers would delegate the decision to the deputy or acting minister. This remained relatively consistent, offering a documented pattern of governance, despite not being in line with what is legally prescribed. In reference to what the case that is being discussed here, brought by the MP and then confirmed on the floor of Parliament, between 2020 and 2024, several different options were introduced, including signing by a deputy, signing by a minister, specifically, as well as signing by a minister specifically on matters related to land, thus creating an issue of a lack of governance patterns within the last 4 years when it comes to issues around land. What are the next steps regarding land conflicts when ministers sign on each other's behalf? The ministry takes any potential irregularities or questionable actions regarding the land allocation very seriously. If there are indications of wrongdoing, the relevant ministries or authorities are contacted and investigations, if necessary, will be undertaken by them. What legal consequences exist for ministers who approve projects against policy advice? Ministers who approve projects against policy advice without legal proper basis or validation may face legal consequences. The following are possible: annulment of decisions. If a decision is made without legal justification, it can be challenged in court and may be annulled, rendering it invalid. Liability claims. Ministers could face personal or government liability if the decision results in financial loss or damage, potentially leading to compensation claims. Administrative and disciplinary actions. The government may take internal measures against the minister, including informal reprimands or investigations into misconduct. Criminal investigations. If a decision involves abuse of power, corruption, or other unlawful actions, the case may be referred to law enforcement agencies. And finally, reputational damage and political consequences. Ministers who act against policy and legal and policy frameworks may face political repercussions, including loss of public trust, parliamentary scrutiny, or even dismissal. What will the government do about questionable land transactions of the past? I refer to my previous answer regarding what can be done. Moving to the questions of MP Roseberg, is there a simplified, publicly accessible version of the objection process for permits? A short informational campaign has been launched 2 weeks ago, including a press release and a misinformational video explaining how residents can object to an approved permit. To keep this top of mind, the video will be shared monthly on social media for better visibility and maximum outreach to the public. Should an informative campaign be launched to educate the population? Key permit procedures will continuously be communicated through social media posts and press releases, ensuring residents stay informed. Will a grace period be given to those unaware of the need for a civil works permit? It is not the intention of the government to dig up all past approved permits.
Minister, please allow me to give the floor to MP Otley, who is requesting an interruption. MP Otley, you have the floor.
Thank you, Madam Chair. Madam Chair, it seems like the public is well engaged in this meeting. I got a text stating that the Honorable Minister did not answer my question that he said he would go back to pertaining to the new policy, and if everyone at this moment who registered for government land would have to reapply. That was not answered, so I just got that from the public, so they're waiting on that answer.
Thank you, MP Otley. Minister, could you address that point?
Thank you, Madam Chair. And as I said, I'll come back to it. If you indulge me, I'll come back to it when we get the corrected answer there, because there's a couple of notes that we're coming back to. Yep. Thank you, Madam Chair.
You may continue,
Yep.
Minister.
Will a grace period be given to those unaware they need a civil works permit? It is not the intention of this government to dig up all past approved permits. As stated, if an issue arises due to the lack of a civil works permit, then we go back to the law to remedy the situation. As stated earlier, we are busy finalizing a policy to efficiently use the permit process for civil works. We are currently assessing the best and most practical solution that serves the public interest while considering the ministry's capacity. New permits are being assessed as they come in to assess the need for a permit beyond the legal requirement. A grace period is being considered as a possible option to allow those who are unaware of the requirements for civil works permit to comply. What are the consequences for non-publication of permits affecting 8% of cases? As stated before, the period for objection is therefore closed, but of course it's jurisprudence that you can appeal within a reasonable time frame, having found out to the judge, and he will consider those options as well. What steps are being taken to ensure that small-scale developments are not disproportionately affected? The ministry, along with the department, is currently working on improving and implementing new methods to improve internal processes to ensure that all permits are evaluated and issued in a timely and efficient manner. This also includes moving towards the digitalization of processes. Yep. And finally, we come to the questions of MP Veronica Janssen. How many building permits were approved between May and November 2024? Between May and November, an estimated 80 permits were approved. Yeah. What is the average time between permit approval and pickup? The average time is usually 2 weeks. Of course, permit approval and pickup, not permit process. That's what we're working on. The average time is usually 2 weeks, but there are times when it varies based on different reasons. Some of these reasons are the applicant might be unable to pay the permit fee right away. The applicant could be off island when they are contacted to pick up their permit. And finally, the applicant does not show up at the designated time given for the permit to be picked up. Who is responsible for calling applicants to pick up permits, and was this affected by the staff member's absence? The permits department's technical administrator is responsible for contacting the applicant and informing them that the permit is ready to be picked up. This indeed did have an effect. Can you provide clarity? This is the MP's final question. Can you provide clarity on delays in publishing permits? This too was answered in several MP's questions regarding what happened. Essentially, a summary very quickly is that between May and November, the approved permits were not issued in the National Gazette, thereby limiting people's possibilities to object. Going back now to the questions of MP Otley, and I think I stated this before my presentation as well, and this will take some time to explain. The impression given that there's a database or a system in which there's a list of all incoming and sort of categorized requests for land is not the case. Most people request government land through a letter to the minister. It goes through in, it goes in div. It sits in the domain affairs desk. It's usually a request saying, I would like a piece of land. They identify a piece of land. It doesn't really have a criteria of what they're going to use the land for. Persons have submitted land requests that vary. Some ask for land, indicate what they want to use it for. So it's a very, very much broad range of reasonable requests and how they request land. What's important to realize is the impression that's being given now is that in this new land policy, it's going to disadvantageously affect people. The reality is, Madam Chair, we have pulled files from the last 4, 10, even 15 years. There are persons who have received land even before those people who have requested land 50 years ago and have not gotten any land. So putting in a request again now is not different than what has happened at all in the last number of years. So all requests basically have to be matched along a criteria that's been made very clear. We can no longer issue land because someone has put in a request before. If that was the case, the requests given over the last 4, 10, 15 years should have never been given, if that is the concern of the MP. The reality is there is no criteria currently for how government issues land. So in actuality, what we're trying to do now is actually make it fair. With that, what we're now saying is we're going to establish as government what land is available when that time comes out. A policy will be drafted in terms of establishing the criteria for that land, and persons will be publicly at the same time made aware of what parcel of land exists. What used to exist in the past is that a person had to go and either go to the cadastre to find a piece of land and, yep.
Minister, no, I give.
Oh, yep.
Minister, with your indulgence, I'll allow MP Otley to make an interruption. MP Otley.
Thank you, Madam Chair. Madam Chair, I'm hearing the minister's elaborate explanation. It's not what I'm asking. I just want a simple question. Persons who have applied for government land at this present moment, whether it's 15, 20 years, 1 month, 2 months, are they then put on the back burner, disregarded, and now will have to reapply? I understand about the past, how it was done, but I'm asking now, persons who applied for government land, would they be disregarded and have to reapply?
And again, yep.
Thank you, MP Otley, for your question. Minister, you may continue, and if you can address the clarification that MP Otley is seeking.
Yes.
For the
Madam Chair, again, that's why I began my presentation by saying, yes, they'll have to reapply. Why? Because there's a I said since the meeting we had about this a couple of months ago, because there is a backlog and there's lots of information missing. We don't necessarily know in Vromi who all has applied for government land. I also stated by saying there are persons who applied for government land the last 4 years, last 10 years, and they got land ahead of people who requested 50 years ago. So the idea of what is being said, it's unfair, and it's, you know, there are persons who applied 50 years ago that applied 4 years ago, and they haven't gotten land. So I think it's very important to make it clear that this actually tries to solve that problem of unfairness. It doesn't make it actually more unfair. I want to also go back to the mention from MP Lewis regarding the restrooms. I will personally, through you, Madam Chair, look into this. These answers were, of course, provided about 2 weeks ago. I'm not aware of the bathrooms at this current moment of this hour of the day, but I will look into it, of course, in remedy situation, because, of course, public restrooms need to be sanitary and, you know, able to be used as a first plate. And then, finally, there was a question, I believe that
Minister,
MP...
just before you conclude, finally, the MP York is seeking an interruption, which I hereby allow. MP York, you may make your interruption.
Thank you, Madam Chair. Madam Chair, I find it quite ironic because when the minister said it earlier, I was like, oh, okay, makes sense. When the minister said good governance is not simply referring to the past, to, they would say, praat goed, what is going on now. And I do understand the reference that the minister is making, but that doesn't neglect the fact that you cannot just disregard people that were there for 10, 20, 30 years officially, because this is now what you're doing officially. So officially putting it aside and saying, hey, reapply. Why not just come on a lottery system and say, hey, those that were there already get extra points? Make it simple. But to just simply say, everybody that's there before officially are null and void, officially, I think that's cutting it a bit short, to be honest. Thank you, Madam Chair.
Thank you, MP York. Minister, you may continue, and if you can address MP York's point.
Yes, no, I think I was relatively clear on that point, Madam Chair. If I can continue my statement, I was asking, I believe it was MP Irion or MP Doran who indicated I had a question that I didn't answer. If we can do that maybe in the, if they can answer in the clarification rounds or in this setting.
Yes, Minister, that was your concluding remark,
Yes.
actually? Okay, so then the MPs who did not have one or more questions answered, you will have the opportunity to do so before we go to the second round, actually in clarifications. So, Minister, and you have finalized your answers. Then, Minister, I want to thank you for the answers provided to questions asked by members of parliament in the first round. Members of parliament, you now have the opportunity to ask any clarification that you would like to have clarified by the minister. To whom can I give the floor at this time for clarifications? I don't see any member requesting clarification, and that would, I do? Yes, I do. I see one, I see two, now I see one, I see MP York. MP York, you have the floor for clarification.
Thank you, Madam Chair. Good afternoon to you. Good afternoon to the Griffier, honorable colleagues, those in the Tribune, the minister and the support staff, and the listening public. Madam Chair, I'll keep this one short. I don't really have much questions for clarification, but the minister, I would like to come back on my interruption from just now. Can the minister clarify through you, Madam Chair, for me, if what he said, because maybe I jumped the gun, if what he said was literally that everyone that applied, that government has on record over the past 10, 20, 30 years, that letters happen to be in a drawer somewhere, that government has identified, if those individuals have to apply again. Based on that example, can the minister clarify that? Subsequently to that, in the beginning, the minister was explaining to you, Madam Chair, the differences, the things that approval of a building permit are approved on, and he mentioned things such as the building code, the hillside policy, the beach policy, the zoning, etc. He also mentioned climate change. So I would like to ask the minister to clarify what he meant with climate change. And for now, that would, and the point of, I think the minister explained it, but I don't think I understood his point 100%. The question of civil work permits, if moving forward, everyone would be subjected to a civil work permit, yes or no? No, we go keep it real short, just yes or no. Will a civil works permit be mandatory for all projects that need a permit? If the minister can clarify those points for me. And also, last one, the minister referenced green zones, being able to raise the value of your property. I would like the minister to elaborate on that further. And with that, that will be it for my clarifications, Madam Chair. Thank you.
Thank you, MP York. I see MP La Cruz is requesting the floor. MP La Cruz, you have the floor.
Blessed afternoon, Madam Chair, Lady Griffier, Minister and his support staff, those in the tribute, my fellow colleagues and those on social media. Madam Chair Lady, I think the minister made a mistake with the answer that he gave, saying that everyone needs to reapply. And I do know why, because as my fellow colleague mentioned, everything in VRAMI is in boxes thrown all over. But I think definitely maybe getting some people on board to start scanning those documents and putting them digital would be a better option, because this will cause a lot of problems. A lot of things will be thrown in the air that I know the minister wouldn't want. So if the minister could really look into that, because the last meeting we had before this, he mentioned that
MP,
something new
clarification.
will be made, put together. And now he's saying that nothing will happen, that everyone needs to reapply. So I'm somewhat confused.
You want that clarified?
Yes, please. Thank you, Madam Chair Lady.
Thank you, MP La Cruz. Okay, so that would be noted as we continue, and I give the floor for clarifications to MP Roseberg. MP Roseberg, you have the floor.
Thank you, Madam Chair. Blessed afternoon to my colleagues and blessed afternoon to the Minister and support staff. Seeing that my colleagues and also during the interruption, they went into that topic, I myself also would like clarification on that matter in regards to if it was said, and if I understood correctly, that it was said that if someone cannot prove that they have the documents available, and then they would have to start over, or they just have to start over, because that wasn't clear to me. So just to avoid any misunderstanding, if the minister can clarify that part. So if you have the proof of documentation that you have submitted it in the past and you show that to the ministry, what will be done then? And if you have nothing to prove, would you have to start over if there's a difference in those two options? Thank you.
Thank you, MP Roseberg. Your clarification request is noted by the ministry, and I continue and I give MP Doran the floor. MP Doran, you have the floor.
Thank you, Madam Chair Lady. Good afternoon to you, my colleagues, the Honorable Minister, his support staff, those that are in the Tribune, and a special good afternoon to the people of St. Martin that are tuned in. Madam Chair, I think that there was some confusion in terms of the responses given to the questions that I posed, because they were all mixed together. So I think that the minister needs to just double check some of the points that were noted. Nevertheless, what I could pick up on, I will ask for clarity right now. I heard the minister mention something about the weighbridge. I remember asking this during the budget debate. I would like to know if the company that was paid in full back in the days before my time, during my time, we started a court proceeding. Did they reciprocate the funds, pay back the funds to government? How far are we with that? Because from what I understand, the government canceled the case against that company that was paid in full. So just clarity on that point based on the minister's response. I would also like to know clarity on the next point, Madam Chair, through you. When receiving conflicting advice, that was one of my questions, from, let's say in this case or in any case, from the permits department and or the policy department regarding a building permit in particular, which one supersedes, and in the minister's opinion, so it's which one does the minister go with? Because there are times that the advice could come from the permits department that is positive, and there are some considerations from the policy department, which is in this case VROM. Which one do you go with? Next clarification through you, Madam Chair, is my question was not about blaming civil servants for anything. Based on the point that the minister brought up, that everyone would require a civil works permit, I'm assuming because of what the minister was busy with at the time, with the case against Westview in this case, I asked a simple question. Would you say that the minister, in that case me, since 2021 when the Article 28 was reintroduced was ill-advised. I'm not throwing anyone under the bus because I don't believe that anyone in the ministry is sitting down behind their computer, spending hours a day to misadvise, mislead, or misinterpret what the law states. Would you say through you, Madam Chair, that the minister was misadvised by the staff because of what they knew at the time, and now that the minister is here in 2025, new information is available? That's all. So not to throw anybody under the bus, but to learn, as the minister mentioned, which I find quite ironic, Madam Chair, because just yesterday I received a forward that was sent around with the minister throwing his own staff under the bus for not giving road work schedules. So it baffles me as to when the minister sees it fit to throw his staff under the bus. Anyway, last one, Madam Chair. I heard the minister mention a lot about holding former office holders accountable, which I like that gesture fully because I agree with that. If you do something wrong, you have to be dealt with based on the confines of the law. Through you, Madam Chair, will you then, Minister, consider former department heads who, in this case, in Alegria case, ask them how much they wanted to pay, and that caused us to right now be in a situation where I am personally being taken to court. I received a letter about 2 weeks ago because of my decision to stand up for the taxi drivers. Through you, Madam Chair, that is a question I would really like clarification on. Thank you for the opportunity.
Question you would like clarification on. Okay, the minister would determine whether it is to clarify something that he said or a new question. And yes, I do see another MP still in clarifications, and I give MP Irion, you change your mind? Oh, okay. Okay, your light is on, MP Irion. We are exchanging mics here, and then I give it to N Cards, and then MP Irion will have the floor. Okay, MP Irion.
Good afternoon again, Madam Chair. Thank you for the answers, Minister. Minister, I would like to start with a comment you made regarding the land, and I want to state that officially, I believe that the law states you cannot disregard persons that have applied for land and tell them to start over. So I just want clarification on that, if your legal advisor could confirm that. Based on the Madam Chair, based on the minister's answers, he's basically stating that the decisions to question who has to and who doesn't have to apply for a civil works permit is subjective, based on his, I guess, on the minister's opinion. Because he also states that he's not going to dig up all the old civil works applications based on old building permits. The minister also stated that, I believe, you could correct me if I'm wrong, that since 2021 there were 554 building permits in line. But then you also mentioned that there are only about less than 70 civil works permits. That's a huge difference. So technically, there's going to be almost 480 persons that are not going to be subjected to you saying, hey, where is your civil works permit? It's just based off of, no, not even what you feel like, based off of, I guess, public pressure, Facebook tags, the media, because in the minister's first presentation, the minister made it clear to us as members of parliament that even if you're doing a septic, you need a civil works permit. He said for everything you need a civil works permit. And that also led to my question. I said, Minister, you're here today. Please start a campaign. Please start educating the population about
your clarification, please.
About the civil works permit. Yes, Madam Chair, that's part of clarification. Because I have to go back to what I said then. Because the minister missed.
What the minister said,
that's also the question. That's also the question that the minister missed, Madam Chair.
Proceed
I
with
made
the
that clear.
clarification.
I made that clear. So that was the question that the minister missed on if you're going to do a campaign or not. And that's when MP Roseberg mentioned about a grace period. So are you going to do a specific campaign, Minister? And that was a question missed through you, Madam Chair. On specifically civil works. Minister, you also mentioned the requirements and you weren't very clear on that, on when an environmental impact study is needed or required. So I want to be clear, I want a clear answer on that. When is an environmental impact study required or needed? And what is the trigger? So what triggers that? And when in the building permit request process, so at one point in time in that process, does that trigger happen? You mentioned regarding, I asked a question regarding civil works again, and you said that civil works permits, again, are based on the discretion of the ministry and the minister, because you're not going to dig up old ones, but it'll be based on if you see excavation happening and so forth. So my question then is to the minister, have you been doing that? So everywhere that excavation is happening, is the department going to check, or have they been checking if they have civil works permits or not? Because again, then it looks very targeted. You also mentioned the amount of permits that came under your tenure and what has been published or not been published. So my question here is, all the ones that you published, do they have a civil works permit? And the ones that you published, will you review and send inspection out to ensure that they all have civil works permits? Because that happened during your tenure. You also mentioned, yes, you could clarify, because you asked easier questions, so clarifying that. True, Madam Chair. You also mentioned, again, the environmental impact. And again, who decides or when is environmental impact required? Is it dependent on when the media says something? When is that required? The minister also mentioned that based on having a green zone could increase the value of your property. That's what the minister mentioned. So I would like to know from the minister, based on what data, what appraisal report, maybe recent appraisal reports from government or even private appraisal reports, where in these appraisal reports show that maybe having green land next to you also increases the value of your property. I think we should be very careful when we say these things on the floor of Parliament. You also mentioned that you have not turned a negative advice into positive, and that if you do want to do that, it has to be properly substantiated. And then you said that in the past that was done, or very little was done, but very little, much, all are subjective. So who determines if it was done enough or done too little? That'd be all, Madam Chair.
Thank you, MP Irion, for those clarification questions. I now give the floor to MP Otley. MP Otley, you have the floor for clarifications.
Thank you, Madam Chair, once again. Madam Chair, my clarification is based on the answer that the minister gave, where my colleague asked about previous permits, and the minister and his cabinet staff, his staff, the department, their willingness to basically dig up all previous permits and see who don't have a civil permit. The minister said that is not the intention. That is, I guess, a bittersweet answer, because to dig everything up will cause a catastrophe, but it creates an unfair just to those that are penalized for this. Madam Chair, through you, we had a meeting recently whereby it was stated that previous ministers wrote previous letters, and ministers, therefore, their hands was tied to sign and continue. So I used that to say to the Honorable Minister, what is then a building permit considered? Because the Honorable Minister refers to the previous minister signing permits, Madam Chair, and stuff not being done right. But to my knowledge, as a minister myself, a previous minister myself, the department renders the advice, and then the minister whether agrees or disagrees. So then, is there not legal ramifications in the case of building permits being given out? If letters can cause court cases, then I'm pretty sure previous building permits can cause court cases and legal ramifications.
Thank you, MP Otley. I don't see any other member requesting clarifications from the minister, so I look to the minister. Minister, would you like some time to consider what time you need for the clarifications, or you can immediately indicate to me what time you would need for the clarifications? Okay, I will adjourn for 2 minutes while the minister caucuses, and we'll come back on the time that he would need for responding to clarifications. This meeting is adjourned for 2 minutes. Meeting adjourned. Members of Parliament, ladies and gentlemen, welcome back after a very brief adjournment, just to allow the Minister to caucus about the time needed for responses to the clarifications as requested by members of Parliament. So right now, I look towards the Minister, and Minister, your proposal to respond to the clarifications, please.
Thank you, Madam Chair. After caucusing with the team, we just have two questions regarding the questions posed to the MP. The question from the MP Doran, if he can reiterate the question, he said, holding former ministers accountable for department heads personally being taken to court. We missed the actual question.
Okay,
I'm not sure if
Minister,
you want
in your introduction, you stated that you missed two questions.
the last question from the MP Doran.
That one you need
regarding former
clarified.
department heads personally being taken to court.
Okay.
What was the actual question? That
Okay,
was
good.
the name.
Okay.
And then the one from, I believe, MP Otley regarding what we have. What is it? No, it was one we have. One with the what we have, we can't use, but doesn't mean we get the, no. Okay, no, previous permits not, yes, there we go. Previous permits not the intention, unfair to those, but he didn't actually ask a question. Was it more a comment, or is there a question to the, regarding the issue with the land issuance?
Okay,
A comment? Okay.
that was a comment.
Okay, perfect. So with that, Madam Chair, just if we can get the clarification what the question, the last question, MP Doran is, and then we are looking at 1 hour requirement for the clarifications.
Okay, MP Doran, I would invite you to clarify your question to the Minister.
Thank you, Madam Chair Lady. The question was, at this point in time, I am personally being taken to court by Alegria Estate for decision that I made in terms of blocking them from getting the water rights for the dolphinarium. I heard the minister give an elaborate explanation in his responses with regards to holding former ministers accountable. With regards to the Alegria situation where you had a department head asking them how much they wanted to pay for the long lease, causing all these hopes and all these dreams of them actually getting it, I asked the minister what is his views in regards to holding former department heads accountable for such actions of misconduct. Thank you.
Thank you, MP Doran. Minister, I believe the question has been clarified, and then you're indicating you need 1 hour to come back with the answers. So then this meeting is hereby adjourned until 5:15, a quarter past the hour of 5. So until then, this meeting will be adjourned. Meeting adjourned until 5:15. Members of Parliament, ladies and gentlemen, thank you for your patience as we allowed the Minister to prepare for the answers to the questions asked by members of Parliament as clarifications to the answers already given. And I hereby welcome back, of course, the members of Parliament and also the Minister of Romy, Patrice Gomes Jr., who will now respond to the answers or respond to the clarifications asked by members of Parliament. Minister, I give you the floor.
Thank you. Thank you, Madam Chair. Pleasant good evening to the members of Parliament once again, those listening and viewing in the Tribune. We received 17 clarification questions, and I begin. The first clarification question came from the MP R12 Irion. Clarify whether the decision about requiring civil works permits is subjective or based on a clear objective policy. The decision to require a civil works permit is based on the law. A minister can make exceptions by ministerial regulation according to Article 28A 12 of the Landsverordening Ruimtelijke Ontwikkelingsplan. The ministry is in the process of finalizing the policy with regards to civil works process, civil permitting process. The purpose of this policy is to ensure that all civil permit requests are evaluated consistently and in compliance with application laws and regulations. This policy will outline the conditions when and where a civil works permit will be required. Will the minister execute a campaign specifically related to civil works permits moving forward? The communications team is busy with several campaigns, including civil works permit, land issuance. This is part of our efforts to enhance education. When is the environmental impact analysis required? What will trigger, or the triggers be, and when? What will the triggers be, and when will they be triggered? The ministry assesses this on a case-by-case basis and requires it based on Article 20 of the Building Ordinance, which mandates the minister to require any further information for an applicant which he deems necessary. Typically, we consider an EIA if the development is proposed in an environmentally sensitive area where impact on the environment may be significant. For instance, if there are by law protected species located in or near the construction site. The ministry is usually advised on this by Nature Foundation, for which we have a service level agreement with. They're typically first asked to execute a rapid environmental, terrestrial, or marine assessment. They then usually indicate if it's a more comprehensive need, thus an environmental impact assessment. The ministry is working on a policy regarding triggers for requirements of an EIA, as these are not formally laid down as yet. Has the ministry been executing inspections at all sites undergoing excavation work? The ministry is executing inspections to the best of its ability. For all building permits, there we go. For all building permits issued in the minister's tenure, do they have a civil works permit? To my knowledge, not all building permits issued during my tenure have a civil works permit. The minister mentioned that having a green zone increases the value of property. I believe these are the questions not from MP Irion anymore. These are clarifications now from MP York. Yes. The minister mentioned having a green zone increases the value of the property. Which data does the minister have to support this statement? This is not yet confirmed for St. Martin specifically. Studies still have to be done. However, in general, studies have shown that urban areas near safe and well-maintained parks can increase surrounding property value. Trees, parks, ponds make an area more attractive and can boost the value of the surrounding residential areas. The same goes for waterfront and sea view properties as well. The minister states that deviating from the ministry's advice requires documented clarification. Who determines if this was done sufficiently in the past? This is a question from MP Irion. MP Irion, allow me to give you some examples of what I mean by very little. In some instances, through you, Madam Chair, in some instances, no substantiation for deviation from draft zoning regarding what can be built or how high is given at all. In other instances, deviating from proper setbacks is not substantiated. To the questions of MP York again, can the minister clarify if what he said is those people who government have on record should be reapplied for government leased land? And let me just, I'll go very slow because I think several people have this exact same question. When the ministry has decided to issue a specific parcel of land with a May brief, the digital system and archives will be checked to the best to the ability of the ministry to see if any previous specific request for this exact piece of land has previously been submitted, which has to be in accordance with Article 4 of the Land Verordening on the policy of land issuance. When such a request is found, this request will, can of course be taken into account, and this person or entity's request can be considered. Seeing that any new issuance in long lease will be done in accordance with the new policy, it might be possible that not sufficient information has been submitted, together with the old requests. If this is the case, this person or entity may be asked to provide additional information in order for the ministry to be able to make a substantial decision based on the new policy. At this time, no final decision have been made regarding the requirements under the upcoming government land policy, as the policy is still being developed. As mentioned earlier, the ministry is currently conducting a tender process to engage a specialist, currently in the midst of a tender process, not conducting one, to engage a specific specialist who will be responsible for drafting the policy. MP York asked the question, what did the minister mean with climate change?
Minister, if you will allow me the possibility to give the floor to MP York for an interruption. MP York, you have the floor.
Thank you, Madam Chair. I would like to just ask the Minister one simple question about the law he just explained to you, Madam Chair. Can the Minister explain what is meant by Article 4 and how does a minister's discretion apply to it as it pertains to the law on DDAM? So if the Minister can explain can he explain Article 4 and how does a minister's discretion apply and how does he plan on applying that to everything he's explaining here today? Because I'm hearing three versions of what he's saying. I'm hearing the version of what the minister says, and I hear the version of what his legal advises him to say. So I want to know what is meant to be executed. Thank you, Madam Chair.
Thank you, MP York. Minister, if you can address MP York's point and continue with your answers. Thank you.
Yep, through you, Madam Chair. Thank you, MP York, for the rebuttal. We'll get back to you when we get through the questions. Okay. So I'll continue, Madam Chair, with the questions as we have
Minister, if you just give me a chance before you continue. It's the minister purview to answer your interruption as he can. So if the minister says, I will address your question posed at the lectern in a while or subsequently, then that is his take on your interruption. So the minister may continue, and as I always ask, Minister, can you take the interruption into consideration, which he said he would do, and respond to at a later moment at least. Minister, you may continue.
Thank you, Madam Chair. The MP York had a question, what does the minister mean by climate change in the context of permits and policies? Climate change directly affects VROMI's work. Climate change causes rising sea level, flooding, erosion, amplifies hurricanes, which all threaten our built and natural environment. Given that VROMI oversees housing, spatial planning, environment, and infrastructure, we cannot ignore and need to consider climate change adaptation measures when addressing new developments. Climate change adaptation is basically addressed in most of our policies. Hillside policy to prevent erosion, and flash flooding of low-lying areas. Beach policy includes construction setbacks to prevent coastline destruction and prevent and mitigate damage to buildings near the coastline. In addition, the building code to enforce buildings against higher category hurricanes is also supposed to be coming into place. Zoning plans include flood-prone areas where building foundation heights need to be a bit higher to prevent flooding. Civil works permits. Will all projects needing a civil works permit need to obtain that going forward? The ministry is in the process of finalizing the policy with regards to civil works permits processes. The purpose of this policy is to ensure that all civil works requests are evaluated consistently and in compliance with applicable laws and regulations. This policy will outline conditions when and where a civil works permit will be required, moving government towards a more efficient and comprehensive style of management. To the clarification questions of MP Doran, the first question, the company that was paid in full in the past for the Way Bridge, a court case was started. What is status? Allow me, Madam Chair, to clarify that no court case was started. The Lands Advocate requested information from the previous cabinet of the minister, and no reply to the information was received. Upon taking office, we convened a meeting regarding the outstanding with the company, are in discussing a way forward, which can include, of course, litigation going forward. When there are conflicting advices between departments, which advice does the minister go with? Which one supersedes the other? To the best of my knowledge, there is no established definition of indicating which department takes precedence when faced with conflicting advices. In such situations, the minister is responsible for considering all input to make an informed decision on the matter. Would the minister say the ministry has misadvised the minister? The ministry advised the minister to their best knowledge and interpretation of the law. Upon the minister's initiative to review the law related to civil works, it became apparent that the interpretation of the minister and the ministry was not the same. What is the view of holding past department heads accountable for misconduct?
Minister, I would ask you to hold your last word or sentence until I allow MP Doran to make use of the interruption lectern. MP Doran, you have the floor.
Thank you, Madam Chair. Through you, Madam Chair, I noticed there's a trend of the minister taking certain words and making his own question out of it. My question was simply when you have a permit advice, so a building permit advice, and there's positive advice, let's say, from the permits department, but there's a conflicting advice from any other department. Which one takes precedence in a permit advisory process? Secondly, I did not say about, I did not mention anything to do with blaming or misleading. I mentioned, can the minister say, based on the civil works and what we're hearing now based on 2021, was the minister, in that case, my person back then, ill-advised based on the advices within the ministry, which the minister has full 100% access to when in regards to civil works? Thank you.
Thank you, MP Doran. Minister, your response to MP Doran, if possible, and you may continue.
Thank you, Madam Chair. I think when it comes to the first question, which was conflict advising between departments on the permit advice, the position still stands. And of course, let me come back again to your question as well on the term misadvising from the ministry. Okay. The MP, another clarification. What is the view of holding past department heads accountable for misconduct? Important to note is that the government is part of the same case that the MP is referring to. The ministry under leadership of Minister Doran, now MP, won this case, and the government is standing behind this position. The ministry places great importance on integrity, good governance, and transparency within the public service. Regardless of rank or position, all government officials are expected to uphold the responsibility standards of their role. With regard to holding former department heads accountable for potential misconduct, the ministry position is clear. if there is a credible indication of wrongdoing or negligence during the tenure, such matters should be properly investigated through a fair and legally sound process. Where appropriate, this may result in corrective or disciplinary action in accordance with applicable laws and regulations. The approach is guided by the principle of accountability, which is fundamental to public service. The Ministry remains committed to strengthening internal controls, improving procedures, and promoting a culture of integrity throughout the organization. At the same time, it is important to clarify the limits of reliance on individual civil servants. Based on established case law, a single informal promise or statement by a civil servant does not in of itself constitute a legally binding commitment. The principle of legitimate expectation in Dutch administrative law requires more stringent criteria. Going on to the questions of, the clarification, of MP La Cruz, can the Minister clarify the thought process with regards to the people having to reapply? MP, through you, Madam Chair, would you like to reread the same answer given to the previous MPs, or? Okay, no need. Moving then to the questions of the MP, Shamida Roseberg. Similarly, she had the same question regarding matters around the government lease land. Let me know, through you, Madam Chair, if it's required to reread the question. Response, sorry.
MP Roseberg, I will allow you to respond.
Thank you, Madam Chair. Yes, I would like to get an answer because my question was not similar to the others, I think.
Clear,
So I would
MP.
like to get my answer
Minister,
clear.
thank you, MP Roseberg. Minister?
So the MP asked the question, Madam Chair, will people have to resubmit if they can prove that they have made an earlier request for government lease land? So the answer was in the request, but I'll read it for clarity's sake. When the Ministry has decided to issue a specific parcel of land with a May brief, digital system and archive will be checked to the best ability of the Ministry to see if any previous requests for the exact piece of land have been previously submitted, which has to be in according to Article 4 of the National Ordinance on Outgiving of Land, which I will clarify for the MP York shortly. When a request is found, this request can, of course, be taken into account, and this person entity may have their request considered. Seeing that any new issuance in long lease will be done in accordance with this new policy, it may be possible that not sufficient information has been submitted together with the old request. If this is the case, the person or entity may have to provide additional information and resubmit this information or submit this information in order for the Ministry to be able to make a substantiated decision based on the new policy. At this time, no final decision has been made regarding the requirements as the land policy is still in development. And finally, Madam Chair, I think we had, let me check. Yeah. The clarification for MP York, can the Minister clarify Article 4 of the National Ordinance on Long Lease Issuance? Article 4 National Ordinance Long Lease is as follows. Anyone who wishes the country to grant them long lease ERFPAC must submit a written request on paper with a stamp addressed to the Minister. It is not possible to deviate from Article 4, meaning no ministerial discretion is possible. This is because it is the law and no possibility to deviate is given in that law. The only option is to adhere to the law.
MP York, I will allow you, albeit an exception, but I will allow you to make your point clear. Are you saying the Minister has not responded or he did not understand? I didn't hear what you said.
Thank you, Madam Chair. Just for clarification's sake, my question was, how does the Minister plan to apply ministerial discretion to Article 4?
Okay.
Along with the description of Article 4 and explaining what it is, the question was, how does he, the Minister, through you, Madam Chair, plan to apply ministerial discretion?
Indeed, I did hear you mention that part of the discretion. So, Minister, could you go into responding to that part of the question?
Yeah. Thank you, Madam Chair, through you, and I think it was stated in my response, it is not possible to deviate from Article 4, meaning no ministerial discretion is possible. And with that, Madam Chair, we've come to the end of the clarifications. And I look forward to any other questions going forward.
Thank you, Minister, for your responses to clarifications. Members of Parliament, we have now reached to the second round, starting with the members of Parliament to pose any additional questions that they might have. And this, of course, goes according to the speakers list. And I start, therefore, with MP Doran. MP Doran, you have the floor.
Thank you, Madam Chair. How much minutes do we have in this round, Madam Chair, for clarity?
10 minutes,
All right,
MP Doran.
Let me hurry up. Minister, thank you for some of the clarifications provided. Madam Chair, through you to the Minister, I want to state the following. When it comes to the SZV and the whole wellness center, the land, the underwater museum, the NEPA land expansion for the kitchen, the Red Cross building, Chamber of Commerce building, the Hills, the marketplace that we're waiting on, Laguna and Bel Air, Aqua, Indigo, just to name a few, and a couple hundred homes, yes, Doran signed those permits. Because, Madam Chair, through you, signing permits was my job. I wasn't responsible for business licenses. I wasn't responsible for signing residency permits. I wasn't responsible for signing food bonds. My job was to sign building permits, Madam Chair. The reason why I bring this up is because a lot of narratives have been put out there as if a lot of wrongdoing took place. But up to now, I haven't heard the minister correct any of it in terms of saying whether something was legal or illegal. It's just a lot of, yes, it was misclassified as residential instead of commercial. But, Madam Chair, with regards to that project in question, the restaurant and the gym and those things that are in part of that project are for the residents. So therefore, it's not as if an outside person can come and take part in it. So it is commercial. I mean, it is residential and not commercial. So for me, Madam Chair, I believe that a lot of things have been spun in a direction to fit a certain narrative, and I understand why. It seems to me, through you, Madam Chair, that the minister is running behind of making tough decisions. While I hear him with a lot of conviction talk about it, I'm not seeing that in action. I'm seeing different. But yeah, that's just my opinion. Madam Chair, through you, my first question to the minister, with regards to the Indigo Bay building permit, Villa 20, right? I've read several articles, some from the minister, some from the Nature Foundation, with talks of a reissuance that took place in 2025. Madam Chair, I'm trying to get some clarity, so that's the first question. Can the minister clarify if a reissuance took place? If not, what did happen with that Villa 20 building permit? Because I remember signing it in early 2024. Madam Chair, to the minister, through you, it has been several weeks now since there have been a great deal of public chatter, accusations, and blame surrounding this topic. In the interest of bringing final clarity and transparency, are you willing to conduct a full audit of the process related to the whole Villa 20 project and all issuing documents? Can that be provided to Parliament? And I'm not talking about a lobbyzook. I would like if the documents can be provided to Parliament through the regular routes as we always receive it. As part of the audit, Madam Chair, through you to the minister, can you ensure that all related documentation is provided, including all advice signed, all permits, all relevant materials? This should include everything related to the granting of the permit for the building, the beach, the road, all associated components from the inception to date. Madam Chair, through you, a couple of weeks ago, a press release was issued addressing the permit situation regarding the same Villa 20, And the minister said he's providing clarity. I didn't really get the clarity, so if the minister can explain here on the floor of Parliament, maybe with his voice he can explain it better so it's not misconceived by anyone, what the clarification really was with regards to that press release. And I also like to know through you, Madam Chair, to the minister, did the building permit issued in 2023 include approval for a beach development or a marina or any breakwaters, as is being referenced in the public, and the minister is not addressing it? Madam Chair, I would also like some clarity on why the construction work on site appears to have been continuing up to recently, despite your public statement, Minister, with regards to an environmental impact study. Could you explain why this is continuing? Minister, over the past few weeks, would you say that there's been a lot of misinformation spread through the media in regards to this project or any other project? Could you identify which information was misinformation and also give some factual information to those that you deem that the persons are misinformed? It was also stated, if I'm not mistaken, here on the floor of Parliament, I know for sure by the Minister of Finance, but I'm trying to remember if the Minister of TIAT mentioned it as well, that the construction sector played a major role in bringing St. Martin back online after our pandemic and during our pandemic. It was said here, numbers were given, factual information. Yet, on the side of the minister now, we're hearing that, overdevelopment and different things. If not, that's an opinion, and I understand that. I would like to know through you, Madam Chair, if the minister was in the seat back in 2020, 2021, 2022, so this is a personal question, what would you have done? I move on, Madam Chair, through you. Considering that you attended the Villa Vent project and publicly stated that the project has government's full support, and in your view, you are partners, what are the specific benefits that you see that this project could bring to the people of St. Martin? I move on, Madam Chair. I heard the minister mention that the project that he signed off, the big development in Maho, had approval of civil aviation and all these things. But Madam Chair, through you, Westview also had approval of civil aviation. All those things had to go through the scrutiny of different parties to make sure that everything was done. It went through the fire safety, back and forth to the fire department. All those things happen. So the misconception that is put out there, Madam Chair, as if one day Mr. Lake and his partners came and put in a paper by the ministry and it was signed maybe under a tree, it's totally misleading. They went through the full scrutiny that everyone else went through, and you know what's even more unfortunate, I would say? That others are right now, currently, as we speak here, 6 p.m., or maybe they finish work at 5. Well, earlier, constructing, doing things without a civil works permit. Yet a small group is being targeted, Madam Chair. And you can't tell me different because I'm seeing it, we all seen it. For 6 months, they were able to build without any interruptions. They went to court because some neighbors took them to court, won the court case, and then here you have the big bad government on the road to stop them from continuing their project, Madam Chair. Where's the law and equality? Where's the law and equality? Madam Chair, I have a couple questions in regards to this. As the civil works do not include building, does the building permit supersede the need to request a civil work permit related to an irrevocable building permit? That is my first question regarding to this subject matter. If the building permit already includes a permission to have sublevels, etc., and the drawings for that work already included in the building permit request, would a civil work permit related to the building activities be redundant? Can I get some clarity on that point? Regarding the law, Article 28A, landsverordening ruimtelijke ontwikkelingsplannen mentions on which the grounds a civil works permit can be denied.
MP, I need to remind
Through
you,
you.
you have 1 minute left.
Whoa!
Yes.
I have to pass my questions to MP Irion or York then? All right, let me finish quick. How does the ministry look upon such denial grounds for persons that have already obtained a building permit that use the same supporting documents for a civil works request? And Madam Chair, lastly, let me jump right to the end with one of the points that I want to bring forward. Here I have a civil works permit signed back in 2012 by then Minister Heiliger of Romy, giving Indigo Bay permission to work on developing a beach. I never heard the minister mention this. I know for sure I didn't sign one. So my question is, Madam Chair, who signed a permit allowing Indigo Bay Development Villavert to develop a beach? Thank you for the opportunity. Those 10 minutes was the quickest 10 minutes of my life. Thank you, Madam Chair.
Thank you, MP Doran. And I continue, and the next speaker is MP Lewis. MP Lewis, you have the floor.
Good evening, Madam Chair. Good evening, Minister. Good evening to those in the Tribune. Good evening, St. Martin, and also good evening to my honorable members of Parliament. To you, Madam Chair, I have a couple of questions for the Minister. I heard it's 10 minutes. I hope we'll fix it in 10 minutes. Is there any law or policy in place if persons can petition the court based on fictive refusal to make a decision? How long does it take after submitting a building permit for a person to receive a response? And if it passes, for example, 7 months, does a person have the right to start building? What procedures in place if a person has to wait so long? Is there a document other than the permit? What is the allotted procession of time for permits applications in general for submission and to the final decision? And what is the current processing time for said procedure? Are there specific benchmarks or timelines the ministry aims to meet in issuing permits? What types of applications are considered for priority processing within the permits department? When a case is given priority, what is the expected timeline compared to the standard applications? Are there currently any applications or developments that have been designated as priority cases? If so, what criteria were there used to determine this? There are recurring reports, Minister. I don't work in the Ministry of Army. The Ministry of Army is not my baby. But when I stand here for the majority. So there are recurring reports that an executive assistant to the minister is frequently, mostly daily, present in the permits department asking about permits. Is this part of their formal responsibilities, or does it raise concerns about the separation between the executive and operation? Is this being done in collaboration with the Secretary General? What safeguards are in place to ensure professional independence and integrity within the Department of Operations? Following the court's ruling on the Westview project in Kupokoi, will the ministry now enforce the requirement that civil work permits must also be obtained, even when a valid building permit exists? Will the ministry apply this standard retroactively or halt ongoing projects that do not meet the full permit requirements? How does the ministry plan to ensure consistency and fairness in enforcing this legal distinction moving forward? While it is understood that the acting department heads are appointed directly by the Secretary General, Could you clarify why someone who reportedly does not meet the requirements outlined in the recent vacancy was placed in this position? There have been reports expressing concerns about the limited availability of the current acting head, who was personally selected for the role. Was there no other staff member within the department or ministry with the necessary technical and managerial expertise to fulfill this role, even temporarily? I ask this question, Minister, as I just do my research as a former detective, and I know that there are other individuals within the department that has also been ministers, for example, in the Ministry of Romy, and also other technical individuals that could have been placed there. It's to the minister's prerogative what he does, but for the general public, in order for this country to move forward, we need the right man for the right job. That would be all for me, Madam Chair. Thank you.
Thank you, MP Lewis. I continue with the list of speakers, and I give the floor to MP Kotai.
Thank you, Madam Chair. I actually do not have anything to ask the Minister at the moment.
Thank you, MP Kotai. The next speaker, according to the speakers list, is MP Veronica Janssen. MP Janssen.
Thank you, Madam Chair. Good afternoon, Minister. Good afternoon, colleagues and the viewing public. I only have one question again regarding the numbers. Since the first building permits were published in November, how many formal objections were received since then? That's my only question. Thank you very much, Madam Chair.
Thank you, MP Janssen. The next member up to speak is MP Peterson. MP Peterson, you have the floor.
Thank you, Madam Chair. A late good afternoon to yourself, to the Honorable Minister and the support staff, to my honorable colleagues sitting here, to the Griffier, Secretariat, and everybody else joining us. Madam Chair, I don't have a lot of questions. I want to thank the Minister for his answers, and it's kind of fun to see how the topic of the meeting kind of strayed from what it was to everything else. And, you know, Minister, not to take up too much of your time, but there were some statements made today that I do think I need to clarify. First of all, through you, Madam Chair, I heard a former minister stand here and say that signing permits is his job. And while I agree, it also should be mentioned that this should happen in the confines of the law. You know, as a minister of an important ministry such as Vromi, indeed, you should take your job seriously when it comes to signing building permits and issuing land. And that being said, issuing land to your relatives is not part of the job. You know, the law also has provisions for that. You know, so we need to be careful, you know, when we tend to go left, when we actually have to walk a straight line. Because what I'm not going to do, Madam Chair, is take the people of St. Martin for fools. And I am tired, Madam Chair, through you, of seeing past ministers hiding behind every single civil servant, every single advice, while they clearly just misunderstood their role. You are responsible. Ministeriële verantwoordelijkheid. And I would encourage all ministers, past and present, to read the job description before you take it, because hiding behind the people who work for you is not the right way to go. Minister, you also mentioned in certain cases that draft zoning was used to deny a permit, while in the others it was basically not even mentioned in the advice. Minister, through you, Madam Chair, have you seen any actual correspondence from a previous minister to a prospective building permit holder in which they were denied a building permit using the draft zoning as a reference, using that as a reason? Because in light of that, Madam Chair, I also want to inquire to the minister, to you, what your stance is. Because to deviate from a draft zoning is clear. It's within the minister's prerogative. That's within your authority. But this, of course, needs to be motivated, motiveringsbeginsel. And who has to motivate that? The minister.
So, Minister, to you, Madam Chair, to you, Minister, if a precedent has been set to communicate to a prospective building permit holder that they cannot get a building permit due to draft zoning, then I believe, in light of good governance and transparency, that this should have been the case in all cases where permits do not correlate with the draft zoning, because that's transparency, that's what's fair. So my question is to you, Minister, if this was not done in another case while this precedent has already been set, is this not the definition of nepotism? Because, Madam Chair, you see what's happening here today is something that I've been advocating against since I was sitting as an opposition member, and that is to subject the people of St. Martin to our, what I would say, show. Right now we have Mr. Lake sitting here, for example, who has been the subject of this. He is the result and the subject of irresponsible decision-making that ultimately led to a court case. You see, the false precedents, well, actually the false pretense that is being put forward that there was a court case already and they won, but now it's government coming. No. There was a case in regards to the access to the property, not the permit, the access to the property, because others also have to use this same property to get access. Okay, so let's not create the misconception that this government came now and is now hammering on locals, because they too are the victim of the same system that we have been hammering over the last couple of months to fix. And this is simple. That you have the authority to make a decision in the name of Country St. Martin does not give you carte blanche in your decision-making. You still need to follow not only the law, but the principles of good governance as well. And in this specific case, the nepotism was clear, Madam Chair. Because yes, while civil aviation was approached, just like all the other high-rises, but the fact is also that that same area, the draft zoning, does not allow more than 10 meters, let alone the approved 61. And if you want to use the minister's authority, then kudos, but then comes back to the motiveringsbeginsel. You need to substantiate why you would want to deviate from a draft zoning that you yourself used to deny a permit to begin with.
MP Peterson, if you give me a moment, I will allow MP Doran to make an interruption.
Let you look.
MP Doran.
Thank you, Madam Chair, for your indulgence, and the MP as well. Madam Chair, I just want to make one thing clear. No matter how we pretend to try to create smoke screens, say one, say two, there's a 14 building there in Mola Bay, which is 21 stories. There are so much different examples. And come high, come low, there's no way that I'm going to sit back and watch local developers be abused by this current government when it comes to this. And in my humble opinion, if others can come here and do good, we should be able to do good in our country. So the MP can continue on the charade of blocking these local developers. Thank you.
Thank you, MP Doran. MP Peterson, you may continue.
Thank you, Madam Chair, for an interruption that, kind of made no sense. But let's come back to the same issue, because these same locals, to my opinion, were used by the previous decision maker and are being used right now to create the smokescreen, because the paperwork is clear. The court case was clear. The facts have been assessed by the judge and they were clear. So again, we need to stop this, Madam Chair. We need to stop making the people the subject to our politics, because guess what? From what I understood, this minister does not want to stop this permit. They actually want to fix what was done, because it was not done right. But you see, when you think that making a decision as a minister reflects on yourself as a person, then you're taking it to heart. Now, Madam Chair, coming back to another point that was made in a clarification, and I think we can lay this point to rest, when it was talking about department heads in the past, talking to other developers or whatever. I think the good MP was specifically talking about myself, because he went to Lady Grace, I think, a couple of years back, where he brought this forward. And it was in that same interview where I had to prove through a recording that I was blackmailed for this exact same situation. So I just want to make it clear that even the judge assessed what the MP was trying to allude to. And indeed, you cannot look at civil servants or anybody that is under the minister and their statements and try to hold government accountable for it. There's jurisprudence on it, not only from the Raad van State, but also in St. Martin as well. So coming back to the fact that developers are now being used as scapegoats for political gain, while the mission of government actually should be to fix the situation, I encourage the minister to continue going after, all of these, I would say, questionable permits that either lack the right advice or the right civil works permit and contact the people and let them do it right. Because government is not here to stop people, government is here to facilitate. And I think that'll be all for me for now, Madam Chair.
Thank you, MP Peterson. I now continue and I give the floor to MP Irion. MP Irion, you have the floor.
Thank you, Madam Chair. Thank you, Minister, for the clarification answers. Minister, you said that civil works permits can be dealt with, so there's a law, but then you can deviate or issue based on a ministerial decree per case. So my question now to the Minister, to Madam Chair, is will the Minister be issuing ministerial decrees for all the missing civil works permits, or will we continue to target only the ones that the Minister wants to target specifically? What would the Minister be looking into? What would your decision be based on to be able to say, hey, for this one, I will be issuing a ministerial decree? Because again, you made it very clear that all need. That ties into my previous question, which you kind of jumbled up with other answers, in terms of the question posed by MP Roseberg and regarding a grace period. I want a very clear answer. Will a grace period be given? What is that based on? When will that be given? When will that decision be made? Regarding the campaign, you mentioned a lot of other campaigns. No, but I want a specific campaign regarding civil works, since that's a very big topic right now. You also mentioned you have over 500 billion permits with only less than 60 civil works permits. There's a big disparity. So obviously something has been going right? And you yourself mentioned, through Madam Chair, the Minister mentioned that all of the building permits that he himself issued don't have civil works permits. So my question now is, Minister, through you, Madam Chair, to the Minister, why didn't the Minister issue civil works permits with the building permits that he published? And are you planning to rectify all of those? All of the building permits that were published through the Minister during his tenure, will the Minister be rectifying that and either stopping those projects and ensuring that all of them have civil work permits? Minister, regarding draft zoning laws, through Madam Chair, what is a draft zoning law? So is it a policy? Because it's not a law, as you mentioned, it's a draft. So how is a draft law? What is the weight behind a draft law? Or is it, do you look at it as a policy? And regarding the draft zoning law, was there ever a town hall meeting, which is a prerequisite for the draft zoning law? Was there ever a town hall meeting held for that process? Minister, in the previous meeting, in your presentation, you mentioned, and you were very forceful about that, about ensuring that we follow the law, and especially if illegal constructions have happened, that you are willing to enforce the law to even destroy construction or buildings that were built illegally. We have a case that I know you're aware of, Manjack Road, Kobe, because that construction now impedes on you and us, government, being able to do the concreting of that road. So what will your decision be? Are you going to enforce the law, as you mentioned, and ensure that the building permit holder builds according to his building permit? Are you going to do a stop order? Have you done a stop order? Do they have a civil works permit? And will you be destroying the building to ensure that we are able to build the road according to the law, Article 22, 6 and 7? What or how does the Ministry of Rumby intend to reconcile a person who has an irrevocable building permit, has already started using the building permit, and receive a denial for civil works permit related to the same building? And regarding the Manjack construction, they already got 2 stop orders, and they still continue to build with those 2 stop orders. So again, Minister, how you plan to enforce it? What is the stance of the ministry for persons with irrevocable building permits related to the civil works permit request? Do these persons still have to apply? If so, wouldn't it make more sense to issue an exemption for persons with irrevocable building permits instead of creating a chicken and egg situation with the already obtained building permit? If no pre-approval can be granted to persons with a building permit, does the ministry plan to go after every person without a civil works permit who has a building permit? If no, what is the criteria for who should be concerned with the ministry stopping their project or their building? For persons who have already completed their building but do not have a civil works permit, if the minister maintains every single person needs a civil works permit, depending on civil works, what is the plan of the minister for those persons who have already completed their construction? And that'll be all, Madam Chair. Thank you.
Thank you, MP Irion. The next member of parliament up to speak is MP La Cruz.
A blessed evening, Madam Chair, Lady Khifir, Minister and his support staff, those in the tribune. Madam Chair, Lady, I only have one question for the Minister, and it goes back to when we spoke during the budget debate last year. I asked the Minister if both ministers, the Minister of TIAT and the Minister of RAMI, if there were any plans to continue with an idea when it comes to publishing a building permit, that right away, if the building will be used as a business, that both publications go out at the same time, so that there will not be 2 times objections being given to a building in a specific location. So if already we know that people will not be okay with the building being used as a business, that from the beginning the Minister of RAMI does think harder about giving a building permit for that location. That will be all. Thank you, Madam Chair.
Thank you, MP La Cruz. I now invite MP York to take the floor.
Thank you, Madam Chair. Once again, good evening to everyone. Good evening to the Minister, support staff, and the viewing public. Minister, to you, Madam Chair, in the beginning, the Minister said that all measures must be carefully weighed before making a decision. Basically, that is his modus operandi, and that is the uitgangspunt, as they would say, before he makes a decision. Madam Chair, I think adjacent to that should also be all things should be carefully thought upon before speaking on. I say that for the following, because as I told the Minister in prior debates, the Minister says a lot of things, and the Minister has to realize that his words carry weight. Because as I listened today, and as I've listened in past debates, some things come around a bit contradictory. Things like saying that all projects, even down to doing septics, needs a civil works permit. Now, while I do agree, understand where the Minister is coming from when he says such a thing like that, I would like to remind the good Minister that his department now has currently 500 odd plus outstanding building permits from the system as is constructed right now. Now, if the Minister meant, Madam Chair, that now everything is going to need a civil works permit, I can only imagine how this number will balloon moving forward. So I would have a question: does the Minister, who already now does not have the infrastructure in place for the current system, does he have the infrastructure in place for the system which he would like to work towards? Because when you say something like, yeah, everything is going to need a civil works permit moving forward, that is not predicting or projecting 2-3 years from now. That is saying what is going to happen tomorrow. So I would like to know, does the Minister have the proper infrastructure in place for that? That being said, the Minister also mentioned that green zones raises the value of one's property. Madam Chair, upon hearing that, I made a couple calls to some appraisers to understand exactly how that works. And the minister even came back on it himself and said, by saying it is not applicable to St. Martin as yet, or basically St. Martin is not that far as yet, but yet he said it, right? So by saying things like that, you put things out there that people will get the wrong understanding, because as the minister said it, a person I respect came to me one time and said, well, Darrell, if that's the case, then I am a millionaire because I have a lot of green in my area, right? So that in itself, just because you want to make a point, when I say you, I'm speaking to all ministers, be careful of what is said or what examples are used, because you will be putting out sometimes a false narrative, whether you mean to or not. Also, the minister in his explanations and in prior I would say videos and also here in Parliament, refers to Villavin as a partner. I would like to remind the good minister, when you say things like that and you refer to a specific developer as a partner, I don't know what that means. Maybe the minister can explain what he means by that, but you're putting out a feeling, if I'm a developer of another project, maybe Westview, and I feel I'm being picked on right now, if the minister calls someone else a partner, then I must question why, if I'm not a partner, if I'm going to be picked on. What constitutes a partner? Because if you use the word partner, minister, it needs to be explained. So again, words carry weight. Additionally to that, the minister spoke on correction of oversights from the past and that there will be a balanced approach, fair and consistent. Otherwise said, rule for one, rule for all. And he also said, through you, Madam Chair, if an issue arises, the situation will be handled because he will be not going through all past permits, which I do understand. But what is considered an issue? Is the issue considered public sentiment or based on fact? And I would think the minister would say based on fact. And if it's based on fact, it makes me even more confused, because if Westview was given a stop order based on a civil works permit not being in order, makes me question why didn't Villavin get a stop order, because their civil works permit is also not in order. Because their civil works permit does not cover the scope of works of which they're executing things on right now. So if it's not in order, why are they given a warning and Westview is given a stop order? And this is why I'm warning the minister, Madam Chair, of using words when explanation, because he called Villavin a partner. So is it because they're a partner, they get a warning, and because Westview is not a partner, they get a stop order? I do not know. I do not want to imply, but I'm just warning the minister of what conclusions using words such as partner and we're working together and all these type of things implies when not used across the board. Moving on, the minister said they are considering options for other developments who are in the same situation as Westview, for example. So why are they being considered for other options? In this case, Westview is just a stop order plain off the bat. Can the minister explain why he did that? Because if we're considering other options for others, rule for one, rule for all, other options should have also been explored for this project. Now, the minister also explained things that are considered during the approval of projects. The minister mentioned things like the building code, the hillside policy, the beach policy, zoning, and climate change. Now, Madam Chair, I asked the minister what he meant by climate change, and he mentioned everything from drainage, erosion, etc., things that are plaguing our society today. So, again, words carry weight. So, if there are developments and projects being graded based on climate change, is that solely for everything that's happened outside of government or also within government? Because I stood here a couple months ago and I warned the minister about things all pertaining to climate change as pertains to the increasing temperatures and all type of things that has to do and applies for asphalt when he was doing the Point Blanche Road. The minister did not bother with what I was saying, and now they continued it based on things prior to climate change, and now when I drive on the road, it feels like I'm driving on rocks. We go in like this when I'm driving on the road. And that's because of climate change, and government project was allowed to continue and not have any consideration for climate change, but here the minister is saying, when others come to get a permit, climate change will be taken into account. Again, words carry weight. As well, 60 permits issued, I think up to maybe December or January, I don't know which to be exact, I stand to be corrected, but the minister has issued 60 plus permits since being in office. But the minister also said, Madam Chair, that they don't all have a civil works permit. So again, rule for one, rule for all. If you're standing here and you're saying everything moving forward will have a civil works permit, why did not apply that to the things that you're signing off today? And if you're saying moving forward, everything will have a civil works permit, and who doesn't, things would have to be corrected, why are old projects from years ago that were signed off years ago being corrected, and not the ones that were just recently signed off, being the 60 that he's referred to, the minister referred to, not all having a civil works permit? Now, Madam Chair, I'm not here standing up fighting on who should have a civil works permit and who should not. I stand with whoever is doing it the right way. If you need a civil works permit, you need a civil works permit. But as I stated in a prior debate, being the TIAT debate, where everything on paper said one thing and everything the minister is doing saying something else, I'm not saying this minister is doing it the exact same way, but I'm trying to say I cannot follow the decision-making of the minister. And if I cannot follow it, people outside cannot follow it as well. And at the end of the day, I'm good. I don't have to agree with what the minister is doing, but I have to be able to follow it. And if I cannot follow it, we have a problem, right? And if I can't follow it, people outside can't follow it, and that's why we have certain people in the Tribune today, because they're coming to find out and understand what is going on and what the thought process is of government. And if these processes are clear, then we wouldn't have these discussions. And if the minister, and I'm in closing, Madam Chair, again, words carry weight. To take the subjectivity out of things, there needs to be a clear line across the board. And with that clear line, I have 1 minute left, Madam Chair, I'm rounding up. With that clear line, there's one question that has been repeated, and that has to do with the land issuance and as it pertains, I think MP E.J has asked that question many times. Do the people who have applied 10, 20, 30 years ago, are they going to be wiped out and you have to apply again? The minister says during round one, he came in, he said, yes, they're going to be wiped out. His LLMs advised him, he came back, he said, no, that's not the case. Today, during the clarification round, he came back, he said again, they're going to be wiped out. He went and spoke to his legal advice came back, he said, no, that's not going to be the case. Then I asked the minister, Madam Chair, hey, minister, can you explain Article 4 and how minister's discretion applies? The minister then says, Article number 4 says, basically, if you don't have a stamp for your request is null and void, and you cannot go around the law. Now, with that again saying, Madam Chair, he is saying something differently to what he said before that, and I would like to remind the good minister, jurisprudence is very serious, and there are manners to go around it to ensure that the people of St. Martin that has applied in the past can get their due justice as it pertains to their request. And with that, Madam Chair, I would like to bring an end to my contribution. Thank you.
Thank you, MP York. The next member to speak is MP De Wever. MP De Wever, you have the floor.
Good evening, Chair Lady, my colleagues, the Minister and his team, and those in the Tribune and still tuned in to this meeting. Madam Chair Lady, this meeting was about delayed publication of building permits and ensuring legal compliance. In the answers that I've received from the Minister, I'm quite content with the answers, but what I have observed based on everything that I've been listening to is that there's still a lot of confusion by the members of Parliament regarding what exactly is supposed to happen with ROMI. And because of that, I will kindly ask the Minister through you if he could actually once again explain to us when a civil works permit is needed, and also explain to us the improvements that he is making in the way that we actually can understand what is happening in the Ministry of ROMI. Because if I'm listening to the dialogue here today, you are hearing certain comments come up that makes it seem like this is a competition between locals and foreigners. This is why my line of questioning in the first round of questions was in the way it was, because I don't want us to have that division here and make it seem or even assume that a minister is doing that. So with that being said, I just want to once again remind the minister just to come out here and explain to us exactly when a civil works permit is needed and when a building permit is needed, and if a building permit does include a civil works permit and vice versa. Because over the years, what has happened in St. Martin is that we have kind of gone willy-nilly in the way that we do things. We do some for our friends, we don't do it for our friends. Those who can pay, those who can't pay. I just want a clear understanding of how things have happened, because that ministry of Rami has gone through a lot of reputational damage, which is, it's done that to the people that have been ministers in there, within persons, working within the ministry as well, to civil servants. So all I want to hear as well, in addition to my questions, is what are the improvements being made by the current minister to ensure that the users of information, when we are making announcements in the National Gazette, actually is available and accessible to everyone who needs to be aware of what is happening in their neighborhood, what is happening next door to them, so that they can actually object in the right manner. And very briefly, I will bring up something that the minister himself may be aware of because of what was brought up last week. And a perfect example of that is that when we are, and this is where I talk about the improvement of our way of working, so that we are not only a partner to the persons that are neighbors, but a partner to everyone on the island, because we're doing the work for the people. So the partner is who we're working for, which is the people. So I'm not going to get stuck on a word like partner, but I believe our partners are the people of St. Martin, every single person living here. So what I want to know is, if Rami is going to improve their way of working, so that when we're actually reading something in a National Gazette, that it's actually not referring to the registered address of the business, but actually the physical geographic location of the business. And I'm only bringing it up because it's something that was there last week, where someone, I believe it was an environmental group, that brought it up again and said, hey, this is not something, they were asking, hey, is this address registered in Colby or is it registered in Point Blanche? And we have to improve our way of working so that our citizens, so that our residents actually doesn't feel like they're being duped by a ministry, or any ministry for that matter. Thank you very much, Madam Chair.
Thank you, MP De Wever. MP Roseburg, you are up.
Thank you, Chair Lady. Good evening to everyone present here tonight. Chair Lady, what I would like to would like to ask, especially seeing that my colleague MP Irion mentioned that it wasn't clearly stated, but when I look back at the recording, I did understand the minister mentioning that a grace period is being considered. That's what was literally said, for the ones that were not aware of the procedure. So my question is specifically when the consideration, when that will be clear, like it's being considered, but is there a clear timeline in regards to that part? Also, I understood the ministry mentioning that there will be awareness campaigns, or that the ministry is already busy with awareness campaigns, and that it will be fall in effect on social media. That was one of my questions, and it was answered in that way. Is that also the case in general, or also for specific matters? Because I understood that, again, my colleague MP Irion was specifically focused on the civil works, but I understood it as in general, so also covering the civil works. But if that's not correct, please specify that, Minister. And if that wasn't in the making as yet, if that can also be taken in consideration. And also, what I would like to get clear is how it's being measured with certain decisions that were taken. And also, in regards to Article 4, I cannot let it slide in the sense of it being mentioned that the law is clear, but jurisprudence is a matter. And as a legal mind, I cannot close my eyes to the fact that if something has been set in place, how do you match it with the jurisprudence connected to it? So I would like to get clarity on that matter, so that the public knows what to expect and how to move forward. Thank you.
Thank you, MP Roseburg. The next MP up to speak is MP Otley. MP Otley, you have the floor.
Thank you, Madam Chair. Good day to the viewing and listening public, the Honorable Minister, once again, his support staff. Madam Chair, for clarity, and maybe it was mentioned, but there's a lot of this, we need a clear distinction. Civil works permit and building permit. Does the civil works permit fall under the building permit process? What happens in a case, someone is given a positive or given their building permit and denied a civil works permit. I ask because you would think that this process is simultaneously. But when I read the article from the Herald pertaining to the court case, it stated that the ministry stated that they overlooked the civil work process. This is what was stated in the Herald, okay? The ministry overlooked. So here it is, this group of developers got their building permit published, no objections, but because it was overlooked, now we have to stop. On top of this, we speak of a judgment. And I understand the judge rendered in favor of Romy. But to my understanding as well, this was an injunction, which means that there is a final court case or final decision to be made later down. Which leads through you, Madam Chair, my next question. What happens if in the final ruling, Westview wins? Are we prepared to pay damages and everything else? So I say that to say this. At the end of the day, Minister of Romy, I hope, through you, Madam Chair, that your ducks are in a row. I really do, because a court case of this magnitude, through you, Madam Chair, if Romy lose, will cost the people of St. Martin almost millions, or more than $1 million. When I hear, through you, Madam Chair, the minister speak today, I'm hearing a lot of discretion. The minister is speaking one thing, and then again another. Let me elaborate. I asked a clear-cut question. Will everyone have to reapply? I got an answer, wasn't clear, through you, Madam Chair. I used my interruption. The answer then given was yes. And then an explanation. I think some members of the coalition catch on that the yes would be in violation with Article 4, Madam Chair, and try to steer the minister in the right direction. After clarification, a different answer was given. So, Madam Chair, for clarity's sake, will everyone have to reapply, or will specific persons who have applied already, missing a document, will they then not have to reapply? Because I'm lost. And if I'm lost, majority of the public definitely is lost. So let's clarify that. Honorable Minister, through you, Madam Chair, my colleague, I will have to say, made a clear point as to why, and I'm interested to hear that answer, why this group was stopped and another group was given a warning. That is very, very important. Now, on the contrary, I also read in the same article that the minister also stated he don't understand why we're in court, and I am willing to work with the developer. So I'm not going to just stare in one direction. The article stated that. So I'm happy, through you, Madam Chair, to the public that may not know, the developers are here in Parliament, the minister is here in Parliament, and based on the minister's sentiment, I hope that that still is the sentiment, Minister, if you are willing to work with this group of developers and get everyone on the right track. Because what's good for the goose has to be good for the gander. And too often, we, as a people of St. Martin, scream, kick, and fight that everyone come here and live the great dream. But too often, we pull our people down. We don't want to see success. And I have always said it as an MP, no one, and I repeat, no one will make me feel guilty for any success that I have. I went to school, I did what I had to do, I worked in the hot sun when everyone was laughing at me. I was, during an election process, discriminated against, lied against, took it to court and won, then I took it to court again and won again. So which means hard work will always pay off. And I want the people of St. Martin to understand, no one should make you feel guilty for your success. And I say that to say this, too often when we see locals doing big projects, it's too big for them. Not saying that that's your sentiment, Minister, but too often it's too big for them. How they get to do that? Where they get the money to do that? But then when are we going to grow? If the Italians, the French, the Dutch, everyone could come to this island and build big villas, build anything, condos, but when our people do it, it becomes a problem. The goal that we should set for the kids, the goal that we should set for our people is indeed for each and every one of us to own our own property, own our own house. But that becomes a blunder. That becomes a political stunt. It's time to change the narrative. It's time to change it now. No pun intended, Lyndon. But it's time to change it. And Madam Chair, through you, my last statement to the Honorable Minister of Rummy is I hope that you and the developers can sit together and work something out. And I would say a message to the developers, through you, Madam Chair. Don't know how it works, but I hope that you are willing to sacrifice what needs to be sacrificed as well to get this project going. Because it'll be a shame if it stops. So I hope that we can meet in the middle. Thank you, Madam Chair.
Thank you, MP Otley. The next speaker up to speak is MP Waver. MP Waver, you have the floor.
Thank you, Madam Chair. Good evening to my colleague MPs, to the Honorable Minister, his support staff, those that are joining us here in the Tribune, and those that are viewing and listening via whichever media. A lot of questions have been asked here this evening about the civil works permits. So I just want, I think, some clarity, in a sense, from the Minister as to if a developer or anyone actually has a permit, a building permit to construct, and apparently in this case, the civil works permit was not issued or was not requested. Is it then that once that is requested, that the persons can continue and build what was actually approved already with the permit? Is that the intention of the minister as well, to sit with the developers and basically say, okay, this is the checklist, this is what was missing. Once you come with this as well, meaning the civil works permit, and once that's approved, then we can issue you the okay, the green light, so to say. And is it maybe also because maybe it's not, I don't know how it went in the beginning, maybe it's not at the fault of the developers, and I'm not talking about any specific developer, that maybe something was missed. So maybe a checklist was not given to them either to say, these are the things that are needed. And based on that, once it is submitted, the civil works permit is submitted, that a soft green light is issued to them as well to say, okay, you can continue with the works while we finalize this process as well. Is that something that the minister is looking, because at the end of the day, developers have been issued a building permit and they seem to be lacking, once again, that. And I think the intention is from government, and especially from the minister, not to delay any works that can improve, I think, our island. I don't think that's ever the intention. So I do echo the sentiments of the MP before me to say that, you know, I think both parties need to be open and sit and come to a resolution as to say, okay, once this is finalized, we can finalize the project. Thank you, Madam Chair.
Thank you, MP Waver. I now give the floor to MP Labega.
Good evening again, everyone. Good evening again, Madam Chair, fellow colleagues, Minister of Rummy support staff, everyone in the Tribune. I have no further questions for the Minister of Rummy. Thank you.
Thank you, MP Labega. Members of Parliament, Minister of Rummy, we have come to the end of the speakers list for the second round with the questions and comments as just made by members of Parliament. Minister, are you able to indicate when you will be able to have the answers to the questions as posed by members of Parliament? I don't expect it to be this evening, but I would like to ask if it can be like next week so that we don't, just prolong meetings. I don't know if you will have everything by then, but if you can come back to respond to a majority of the questions, at least we can act and react to meetings quickly. I'm allowing the minister just a minute. I would not even adjourn. Members of Parliament, the meeting is not adjourned as the minister is caucusing with his team, and we will get an answer as to the continuation of this meeting shortly. I think the minister is ready to respond. Minister, in terms of the continuation of this meeting, which hinges on you being able to provide answers, I would like to hear from you when and how that can be.
Thank you, Madam Chair. Next week, we have to unfortunately travel for an emergency situation that we're dealing with regards to some updates regarding some EDMP, World Bank Trust Fund projects. So I would like to propose, if possible, I know some of the MPs are not here, but we can push to try and come back on Friday afternoon. If not, we'd have to then do it the week after this time. So we're not in the country next week. So
Thank
either
you.
this Friday or,
yeah. Thank you, Minister. That's thank you for really considering. I really appreciate you considering returning on Friday. Given several matters, not only that some of the MPs will not be here, and MPs, that is not always the case. So I am really considering that many of you are not on island. So, Minister, I would want to suggest that we put it off for the week after. It also gives our secretariat, time to follow up and catch up with some of the meetings and reports. So with that, Minister, once again, thank you for the offer. The exact date after next week will be communicated between our secretariat and your office. And so, members of Parliament, I want to thank you for your participation. Ladies and gentlemen, thank you for tuning in. Minister, thank you for being here. And this meeting is hereby adjourned, and the exact date of continuation will be communicated. Meeting adjourned.